My lord, I beg to mention one thing, my lord. So for item number 15 is concerned, my lord.
Yes.
Both myself and my junior, we have actually want to withdraw the case and we have already withdrawn. Nama. We want to withdraw our Nama. We do not want to be in the case.
Okay. Have you sent
And
it?
we have already informed. And he has, actually we have returned the files also. He told.
Okay. Is there any state of yours?
My lord?
You are for the
Control.
petitioner?
He,
Okay.
we are for the petitioner.
Okay, you be there when the order is to be passed. We'll pass the order.
Yes. Must
He
have.
need not be present. He be there. You be there.
No, he also want to.
I also want to.
Right, you be there.
No.
Let the matter reach. I'll pass the appropriate order. You need
Both
not
of
be.
us, because he has taken.
Let him
Yes.
be there.
No, he does not want to be here, sir. Oh, hard time. Okay. Yes. Okay. Must have been.
He need not be
Must-
present in the
yes.
court.
Oh,
Right.
yes.
Let him be
Must-
present. I'll pass the necessary order.
Must have
After
been.
going to the
Yes.
case record.
I have left.
Tomorrow for withdrawal.
Item number 22. Okay, on the prayer of Mr. Huh? Okay. On the request of Mr. A. Raman, Learned Counsel for the petitioners. List the case when? List the case on so and so. After 2 weeks. It Mr. MP Goswami, Learned S.H. Vora, Learned Additional Public Prosecutor for the respondent state is
13-2.
submitted that the state has no objection to prayer for adjournment.
I beg to mention item number 3, Lord.
Item number 3, yes.
The agenda for a week, Lord. My senior is not working.
Okay, on the request of Mr.
MS Model.
Learned Counsel for the petition, list the case on so and so. S.H.
6-2,
Vora
6-2.
present.
May I please, your Lordship? Lordship, beg to mention few items, Lordship. Adjournment slip has been circulated, Lordship, for item number 1, 2, 30 and 32, Lordship. Senior Lordship undergone surgery, Lordship.
Okay, Mr.
A. Mena, Lordship.
A. Mena, Learned Counsel for the petitioner has submitted that the leading counsel has undergone a surgery recently and has on that ground he has sought an adjournment of the case with the consent of Learned Additional Public Prosecutor, Ms. S.H. Vora. Post of the prayer is allowed. Release the case on.
Lordship, in item number 30, Lordship, there is an interim, Lordship.
1
Interim
minute.
shall continue.
Item number 1, huh?
Lordship.
You have circulated mention memo or
Yes,
what?
yes, Lordship.
Okay, a mention memo to that effect has also been circulated yesterday. List the case on so and so.
6-2.
Prayer is allowed. List the case on so
6
and so.
February.
Lordship, item number 32. Lordship.
Item 2, item 1 and 2.
Yes, Lordship.
Then
30, Lordship.
30.
30. There is an interim, Lordship.
30. Okay, to validate for date 0. Interim or past release shall continue till the next set of list.
16-2.
And?
And 32, Lordship.
Okay.
32.
Same view.
16-2.
Deeply obliged, Lordship.
Give it to the court master.
Wait, please, Lordship. I beg to mention for listing of a criminal appeal, Lordship. The matter was last listed on in the year 2024 only, Lordship.
Okay, give it to the court master.
Lordship, obliged.
I'm paying for a list of higher criminal document.
Give it.
Will be on Friday.
No, give it to the court master.
We are filing on 2012.
No matter.
May I please, your Lordship? I'm going to mention one criminal revision petition for listing, Lordship.
Okay, give it to the court master.
Wait, Mr. Lordship. In item 15, the
Item
18.
18.
Scan copy of the TCR was called for. I have checked the file and that has not been received, Lordship.
18 reaction.
I have taken the concern of the others as well.
Mr. N. Hassan, Learned Counsel for the petitioner, and S.H. Bora, Learned Additional Public Prosecutor, respondent number 1,
Office note I have.
state or present post of service is complete.
Complete, Lordship.
No.
Complete, Lordship.
Oh,
I've informed the council.
okay. Peruse the office note dated 22/01/2026. Post of TCR, as called for, has not yet been received. Post of release the case on
2002.
May I please, Lordship, sir, back to mention item number 19, Lordship. What's the
19,
19?
19.
19, Lordship. Lordship, case diary was called for, Lordship. Lordship.
Okay. Mr.
Mr. B. Borgohain on behalf of K. Thakur, Lordship.
Mr. B. Borgohain. 19.
19, Lordship.
Okay. Ms. S.H. Bora, Learned Additional Public Prosecutor, has submitted that the case diary as called for has not yet been received. Post of Ms. Bora has just sought for listing of the case on what date, Ms. Bora? 9/2. Please the
What?
case accordingly on 9/2.
That's okay.
Deadly list for motion. Item number 4.
My previous Lordship. The allegation will, my lord, this prayer is for causing of the complaint arising out of the offense report filed by the respondent number 2, my lord. The offense report, my lord, you will find at page 15, my lord. The allegation is that I have trespassed and have constructed upon the land of the forest department. Whereas the
15.
15, my lord,
15.
15,
Forest not there. Okay, after some time.
Item 5.
One minute.
My lord.
Indiscriminate. 1 minute. Just a minute. Rupali Devi is under for section 498A.
My lord.
Ah.
So this Rupali Devi,
No, this
this-
is 498A.
498. So, my
That I
lord,
wrongly remembered.
yes,
Hmm.
my lord, in this particular case, the petitioner who has filed the complaint case, both the cases are out of the same cause of action. And she has taken the shelter.
That can be done.
Yes. And she has taken the shelter of her elder sister that she is staying in Bongaigaon. On that basis, she has taken instituted the case at Bongaigaon. Whereas her elder sister, she has filed the case in New Jalpaiguri. There she has stated
Let
that
us
her
see, let us see first 144 144 petition. Firstly, separate proceedings, independent proceedings cannot be challenged
my lord, in this regard, the
in one petition.
in one petition there I rely on this AIR 2021 volume 5 Supreme Court cases 435. There
To us.
kindly. Not only the lordship of honorable
Show us, give us.
kindly.
Where is 144 petition? Where is 144 petition?
Oh, 144.
Rajneesh already. 144 petition.
My lord. Good question.
I don't know, territory jurisdiction found. Right, Islam. Where is that? Ah. Nothing.
My lord, this 144 petition, it is not annexed to this petition. My lord, this 144 petition, annexure number 11 may kindly be paged. Page number
I have
54.
already got it. And where is 12 DVR, DVGate Act?
Th- This case is annexure number. My lord, it is annexure number 12
DVA খনৰো
and page number
SS.
61 the complaint starts and page number 63 there the same cause of action 28/6/2024.
deviate myself. Hmm. Which paragraph? Krishna Lal Savla?
It is last para, my lord. In Krishnalal Chawla,
Hmm.
that the
Last para?
last para, the proceedings of the, I read out, my lords,
Huh.
para 30, that the proceedings in complaint case number 2943 of 2018, including the order summons against the appellants dated 4/4/2019 be quashed.
Okay.
Further proceeding pursuant to NCR 158 of 2012
Huh.
dated 5/8/2012 filed by the respondent number 2 also quashed in order to foreclose further frivolous litigation.
Hmm.
And any number 30, para number 32,
Hmm.
that any other criminal cases between the parties initiated by them in relation to incident of 5/8/2012, including the criminal proceedings arising from NCR number 160 of 2012, crime number 283 of 2017, instituted by the appellant, are quashed in exercise of the powers under Article 142 of the Constitution in the interest of giving quietus to these criminal proceedings arising out of a petty incident of 9 years ago.
Respondent find what's happened.
So, my lord, in this particular case, that
Hmm.
more than one proceeding has been quashed by the Lordship of Honorable Apex Court.
And you preferred petition for on the ground of lack of territorial jurisdiction.
My lord,
And the court has passed the order dismissing the petition. Now, what is your case for transfer?
my
Quashing?
my question is that
Lack of
the
jurisdiction.
the Bongaigaon court has got no jurisdiction.
Okay.
And the shelter the petitioner has taken before the Bongaigaon
Hmm.
court is that
Hmm.
her elders, she has taken the shelter under the elder sister, and
Hmm.
elder sister is residing in Bongaigaon. But the very elder sister has instituted a case in Shiliguri. There she has categorically stated, at present residing at Hatisar, PO Deosari, PS Runikatha, District Chirang, Assam.
Which one?
Page number 80 may kindly be perused.
Page
Annexure number
number
50. 80, 80.
80. This is when 2025.
This is, my lord, it is filed on 21/7/2025. There, the elder sister has disclosed that at present my address is at Deosari under Chirang district. So how the cases can be filed at Bongaigaon and how the Bongaigaon court can take the jurisdiction? Totally, the learned lower court has been misguided. in both the annexure number 11 and 12, my lord can peruse the very page number
B.
54 and 57, where she has categorically stated
Which
that-
paragraph?
the page number 54, annexure number 11, at present reside.
No. Sister, elder sister. Which
El-
paragraph?
Elder sister, my lord, the first line may kindly be perused, where the address is given. Srimati Beauty Kumari Gupta, Beauty alias Beauty Roy Gupta, wife of Rabindra Kumar Roy, and daughter of Sri Rambabu Gupta, father,
July.
and Srimati Tara Devi Prasad, mother, at present residing at Hatisar, P.O. Deosari, P.S. Runikatha, District Chirang, Assam. And PIN number is also given.
July. December. Yes, anything?
So, my lord, I pray that this, both the proceeding before the learned lower court at Bongaigaon may kindly be stayed. And notices may be issued to the present opposite party respondent that later.
Mr. Nandi, we find no case. So no question of issuing notice. Heard, Mr. D. Nandi. And what is this matrimonial suit?
Matrimonial suit is it is the DV case has been filed.
Huh? Matrimonial suit?
This matrimonial suit of the elder sister is relating to mutual divorce.
That is the one.
Yes.
Meghalaya?
No,
What is-
this is the divorce case. Because after repeated persuasions, when the wife did not turn up, thereafter, the present petitioner husband, he was compelled to file a suit. And after that filing of that suit also, he pursued. So that the wife comes up. But the wife, she is having her own business at Chirang. And that is why she did not turn up. And in this, the very judgment itself, the twice the registered post notices were issued by the learned district judge.
One has treated the petitions with cruelty. What are the reliefs sought in the DV case?
In the DV case,
Between 19, 20, 21, 23. Okay. This criminal petition under section 528
my lord,
Bharatiya Nagarik. I have seen Puraksha Honita 2023 is preferred.
my salary is only 17,000.
No, we are not deciding that.
No. Yes,
We are not deciding that.
my lord.
We are only regarding the validity of the order passed by the trial court
Yes,
and regarding your prayer of lack of jurisdiction.
yes.
On merits, we are not entering into.
Okay.
That is to be independently decided. We are not going into the merits of other issues. Seeking quashing of two proceedings. Comma, miss case number 105 stroke 2024 and DVCR case number 2 stroke 2025, comma, both, comma, presently pending before the court of learned additional chief judicial magistrate, comma, Bongaigaon, Assam, between the petitioner and the respondent. Full stop. Para. The proceedings of miss case number 105 stroke 2024 has been initiated by the respondent under section 144B and SS 2023 within bracket earlier section 125 CRPC, Code of Criminal Procedure 1973. Seeking maintenance from the petitioner, monthly maintenance allowance from the petitioner for the respondent and her minor child. Full stop. Para. The proceedings of DVCR case number 2 stroke 2025 is initiated by the respondents by filing an application under section 12, protection of women from Domestic Violence Act 2005 within brackets, quote unquote, the DV Act for short. Seeking reliefs. No, against the petitioner and other 5 other family members, stroke relatives of the petitioners, seeking reliefs under section 18, comma, section 19, section 20, Section 21 and Section 21 of the DB Act 2000, DB Act. Full stop. Para. In the petition filed under Section 144 BNSS, as well as in a petition filed under Section 12 DV Act, the respondent has stated that the marriage between the petitioner and the respondent was solemnized on 5/6/2023 at Siliguri as per Hindu rights and customs. Full stop. A after marriage, the spouses started living together in the matrimonial house at village Tikri, Tikrilla, district West Garo Hills, Meghalaya. Full stop. The respondent has further mentioned that in the month of May 2024, a girl child who was born to the petitioner and the respondent. Full stop. The respondent has further alleged that since after the marriage, the petitioner and his family members had inflicted cruelty, both mental and physical, upon the respondent, and finding no option for full stop. Finally, on 28/6/2024, the petitioner and his family members drove the respondent and her minor daughter out from her matrimonial house. Full stop. Para. On institution of the two proceedings before the court of learned Additional Chief Judicial Magistrate, Bongaigaon, Assam. The trial court for short. Notices were issued to the petitioner in Miss Case number 105/2024 and to the petitioner and his other family members, who have been arraigned as respondents, in DVCR case number so and so. Full stop. Para. Upon receipt of notice, the petitioner in Miss Case number so and so filed a petition under section 125B and SS. Raising a ground that the court at Bongaigaon, the trial court at Bongaigaon, did not have the territorial jurisdiction to try the petition filed under section 144B and SS. First of the said petition was numbered and registered as said petition, filed on 29/4/2025, was numbered as petition number 1553/2025. Did not have jurisdiction under section 145 PNSS. Para. Similarly, in DVCR case number so and so, the respondents, including the petitioner, within bracket respond number 1, as within bracket as respond number 1, file a petition, petition number 1609/2025. Stating that the trial court at Bongaigaon did not have territorial jurisdiction under section 27 DV Act to adjudicate the proceedings filed by the respondent seeking various reliefs under DV Act. Full stop. Para. The common ground asserted in petition number 15532/2025 and petition number 1609/2025. 1609 to 25/2025, dated. Where that the marriage between the petitioner and the respondent was solemnized at Siliguri, West Bengal, and after marriage, they last resided together at Tikritila, West Garo Hills, Meghalaya. Full stop. It was further mentioned that after the respondent left the matrimonial house, she started residing with her mother at village Hatisar, police station Basugaon, district Sirang, and in both the proceedings, comma, the respondent had falsely mentioned the address of her sister at Bongaigaon to file the case at Bongaigaon. Full stop. Para. The trial court, comma, by an order dated 20/09/2025, dismissed the petition on so and so by an order dated, comma, in an order dated so and so, passed in connection with petition number 1556/2024, has observed that from the materials on record, it had appeared prima facie that the petitioner herein, that is the respondent herein, had started residing with her elder sister at her residence at Bongaigaon, and therefore the trial court would have the jurisdiction to proceed with the proceedings under section 144B and SS. Full stop. The trial court has further observed that the question as to whether the petitioner had actually resided at Bongaigaon or that she had just mentioned the address at Bongaigaon falsely only to file the case at Bongaigaon would be a tribal issue. Full stop. The trial court had trial court, in respect of petition number 1609/2025, filed in DVCR case number so and so, the trial court has observed similarly in an order dated 20/09/2020. Full stop. Para. The trial court, while considering petition number 1553/2025, has considered the provisions of section 144 and section 145 of the BNSS. Full stop. In connection with petition number 1609/2025, in DVCR case number so and so, the trial court has considered the provisions of section 27 of the DV Act. Full stop. Para. It is the contention of the petitioner that the petitioner had instituted a proceeding in the form of matrimonial suit number 15/2024 under section 13 within bracket 1 within bracket small IA, comma, Hindu Marriage Act 1955, seeking for a decree for dissolution of the marriage. Full stop. And by a Judgment and order dated 19/9/2025, comma, past ex parte, comma, the Court of Learned District Judge Tura has passed a decree for dissolution, has dissolved the marriage between the petitioner and the respondent by a decree of divorce. First off, it is the further contention of the petitioner that the elder sister of the respondent, VIZ, Srimati Beauty Kumari Gupta, had instituted a proceeding under Section 13B of the Hindu Marriage Act 1955 as the petitioner, number one, before the Court of Learned Additional District Judge, First Court, Siliguri, in July 2025 for a decree of divorce on mutual consent for resolution of her marriage, comma, solemnized on 24/7/2015, comma, with the petition number 2, PIJ Sri Robindra Kumar Rai, full stop. In the said matrimonial proceeding, the said application under Section 13B Hindu Marriage Act 1955 has been registered as Mat Suit number 181/2025. And in the said petition, comma, Srimati Beauty Kumari Gupta had mentioned her present address at Hatisar, Post Office Deusiri, PS Runikata, District Sirang, Assam, post of. With such projection, comma, the Learned Counsel for the petitioner has submitted that when the elder sister of the petitioner had mentioned her was residing at District Sirang, the respondent herein could not have instituted the two proceedings in District Bongaigaon, Assam, as her permanent resident, as she is a permanent resident of District Sirang, Assam, post of para. At this post of before. So it is no, at this stage, it is really to refer to the provisions of Section 145 BNSS, comma, which provision of 145 provision, which is similarly worded with reconduction CRPC. It is no, it can be. It is noticed that Section 144 BNSS is similarly worded as like the provision of Section 125 CRPC. Full stop. Likewise, comma, Section 1 45 BNSS is similar to Section 126 CRPC. First off, for ready reference, Section 145 of the BNSS is quoted herein under 145. Section 27 of the DV Act has dealt with the issue of jurisdiction. And Section 27 reads as under para. In the petitions or applications ki kochilo, hetu ekala kibo. In the applications filed under Section 144 BNSS and Section 12 of the DV Act, the sole respondent, the respondent herein has asserted that after she was driven out of her matrimonial house on 28/6/2024, she returned back to her parental house, full stop, as her father is a paralyzed person and her mother is a sick lady, an old and sick woman, she was compelled to take shelter at her elder sister's house along with her daughter. Full stop. After 28/6/2024, there was no effort from her husband to take her back to the matrimonial house, nor he had provided any maintenance to her till the filing of the applications before the trial court at Bongaigaon. Full stop. Para. The proceeding under Section 144 BNSS was instituted in December 2024, whereas the proceeding under Section 12 of the DV Act was initiated in early part of January 2025. Full stop. The proceedings of the petition under Section 13B Hindu Marriage Act was filed by the elder sister of the petitioner on 19/7/2000. It transpires. On 19/7/2025. Full stop. In match suit number 15/2024, the lower court had observed that notice to the respondent therein was sent twice, and the respondent had, despite receipt of, sent twice by registered post, and despite receipt of the notice, the respondent did not contest. And therefore, the suit had to be proceeded ex parte against the respondent. Full stop. Para. The learned trial court, while deciding the issue of territorial jurisdiction to try and adjudicate the application under 144 BNSS and Section 12 of the DB Act, has found that it has the territorial jurisdiction. It has found primacy that it has the territorial jurisdiction to try and adjudicate the applications under Section 145 BNSS within bracket earlier, 126 CRPC and Section 27, DB Act. Full stop. Para. The law is well settled that a wife can make a claim for maintenance under different statutes, and there is no bar to seek maintenance both under the DB Act and under Section 144 BNSS within bracket earlier Section 125 CRPC. Full stop. Observing the fact that there are overlapping jurisdictions under various statutes, the Honorable Supreme Court in Rajneesh versus Neha and another 2021 2 SSC 324 has observed that it would be inequitable. No. If maintenance is awarded to the wife in a previously instituted proceeding, she is under a legal obligation to disclose the same in a subsequent proceeding for maintenance, which may be filed under another enactment. Full stop. While deciding the quantum of maintenance in the subsequent proceeding, the civil court / family court shall take into account the maintenance awarded in any previously instituted proceeding, and determine the maintenance payable to the claimant. Full stop. To overcome the issue of overlapping jurisdiction, and to avoid conflicting orders being passed in different proceedings, the Supreme Court has directed that in a subsequent maintenance proceeding, the applicant shall disclose the previous maintenance proceeding, and the orders passed therein, so that the court would take into consideration the maintenance already awarded in the previous proceeding, and grant an adjustment or set-off of the said amount. Full stop. While passing such a direction, the Supreme Court has noted that has taken into consideration that the proceedings under Section 125 CRPC is independent, is a separate proceeding from the proceeding under Section 12 of the Domestic DV Act. And there are, however, overlapping jurisdictions. Post law. Meaning thereby come under proceedings under Section 144 BNSS and Section 12 DB Act are separate proceedings, and as such, orders passed in orders passed separately in the two proceedings are required to be filed, are required to be challenged separately. And as such, the maintainability of the present criminal petition is questionable. Post of be that as it may, be that as it may, full stop, para. As per in there has been clear averment statement in the application under Section 144 BNSS as well as in the application under Section 12 DB Act that after being driven out of her matrimonial house, the respondent was compelled to take shelter in the house of the elder sister for the reasons mentioned above, therein, and alluded herein above. Full stop. Para. In Darshan Kumari, SMT versus Surinder Kumar, 1995, Supply 4 SCC 137, the appellant was a divorcee from the respondent. Full stop. The appellant made in her application for maintenance under Section 125, read with Section 126 of the Code, filed before the Court of Learned Magistrate NUH, made a statement, categorical statement that she had been residing with her brother at Nu. Full stop. The High Court and the Learned Magistrate and the magistrate, where the matter of residence was challenged, and consequently the territorial jurisdiction, had observed that had reached a conclusion that the appellant was not residing at Nu because, according to the respondent, that was not her permanent residence. Full stop. The Supreme Court has observed that Section 126 of the Code requires that the proceedings under Section 125 may be taken against any person in any district where he or his wife resides, The section does not require permanent residence at the said place, full stop. Even a temporary residence, comma, so long as it is not casual, comma, is sufficient to confer jurisdiction on the magistrate at that place or of the district concerned, full stop. The Supreme Court has observed that the view that the findings of the High Court was incorrect, full stop. The appellant was entitled to prosecute the application in the court of learned magistrate at No, where, as per his averment in the application, she was residing and was still residing. Or she was residing, full stop, para. Having regard to the provisions of section 27 of the DB Act, comma, the Supreme Court in Shyamlal Devda and others versus Porimala has taken into consideration the provisions of section 27 of the DB Act. Agrohin category. The matrimonial house of the spouses therein was at Chennai. Full stop. Full stop. In that connection, comma, the Supreme Court has observed as under. With regard to section 20, with regard to jurisdiction under section 27 DB Act, the Supreme Court has observed as under paragraph 11. Para. In view of the aforestated position of law, we find no infirmity either in the order dated 20/09/2025 passed by the trial court in Miss case number so and so, or in the order dated 20/09/2025 passed in passed in DVCR case number so and so. First of, consequently, comma, this criminal petition is bereft of merit, and being bereft of merit, comma, is one which is not to be entertained. First of, reasons lengthy, comma, the criminal petition is dismissed.
Item 6.
Para. The decision, one more. The decision in Krishnalal Saula and others versus State of Uttar Pradesh and another 2021-5 SCC 435, comma, relied on by the learned counsel for the petitioner, comma, is with regard to frivolous or vexatious complaints, and is found to be of no assistance to the case of the petition.
Number 6.
Please conclude.
May I please, your lordship?
Just a minute. Yes. Yes.
My lord, this matter also challenging a order of the DB Act, my lord. But in this case, my lord, your lordship had passed an order in the maintenance case on 18/8/25, staying the maintenance order on the ground that the wife is earning member and she earns approximately to the,
Who is order?
yes, page number 26. Your lordship order 18/8, page 26, your lordship.
Yes,
Uh,
26.
26, your lordship.
26. Passed by the family court at Guwahati instead of by the family court as direct petitioner.
27, page.
One minute.
Yes.
The opposite party pay an amount of was monthly minutes to respondent wife under section so and so. Both are government employees on that grounds.
Yes, my
But
lord.
prior to her appointment, she was entitled for maintenance.
Yes, my
So
lord.
there is an interim observation.
Yes, my lord.
Yes.
Accordingly, the petitioner paid that amount and your lordship stayed the order.
Ah.
Immediately after 15 days of this order, your lordship, the wife filed a DB case after 4.5 years.
Hmm.
And this is a retaliatory measure, your lordship, to take a revenge against all the family members, including a married sister of the petitioner and a younger brother who is.
What is the 125 application? Is it available here?
Yes, my lord. 125 is page number 21, my lord.
Page number 21.
21, yes, my lord.
Page number 21. What did he say when she was driven out allegedly?
Yes.
When?
10/6, your lordship.
What is that statement?
26/21.
10/6.
Yes, my lord.
And where is the present DB proceeding?
Present DB proceeding, your lordship, in the form of an additional affidavit, I have brought my lord, because it is a bulky petition, my lord. Page number, your lordship, 39.
39.
Running page, your lordship.
39.
39, your lordship.
So when it was instituted?
On 2nd of September, your lordship.
2nd of September.
2nd of September.
Where is the notice issued to you?
Notice, your lordship, in page number 36. Page number 36, your lordship.
36 notice.
36. For the main petition, your
Huh?
lordship.
Main petition.
Main petition, your lordship. Last page of the petition, my lord.
Page number 30.
36. Including.
Okay, where is the petition?
My lord, DB petition, my lord. DB petition, page number 39, my lord.
Anything about maintenance case already mentioned?
Mentioned, your lord, mentioned.
Hmm?
But my lord,
Okay.
it is not mentioned regarding the payment of.
Mentioned.
Not mentioned about the payment, subject to the payment of the arrear amount. That
Okay.
is not disclosed.
Okay.
So,
Before the Guwahati High Court criminal petition, you should
Yes.
notice stay the operation.
state operation. But
Ah,
regarding payment, no
okay.
mention is there.
Facts are mentioned.
First mention, your lordship. Now, kindly, your lordship, the respondents kindly, page number 40. Page number 40. The petitioner, his mother, three is the
Respondent number 1?
one is the petitioner,
Petitioner.
2 is the mother,
2 is the mother.
3 is the younger brother,
Brother.
who is already in the FIR. When there was a FIR 498A. 4 is the Nur Islam Ali.
Who is he?
He is the brother who is posted at Orang National Park. He is serving from the year 2011, your lordship. He was not a party in the FIR, which was immediately filed. now included this person. 5 is the unmarried daughter, unmarried sister of the petitioner, your lordship,
Accused,
accused. and
already accused.
already accused.
Ah.
And 6 is the married daughter. She was not accused in the FIR, your lordship. That was filed immediately after she
There is
left.
married sister.
Married sister, your lordship.
Hmm.
So these 2 persons presently to take revenge, retaliatory measure, these 2 persons included in this DB case, your lordship.
Hmm.
Your lordship I will draw your lordship attention, page number 66 is the FIR. Page number 66, your lordship. Acha, yes.
Dunia. Noor Islam Ali.
Page number 66, your lordship, is the FIR.
Narijan. Okay, they are not there.
They are not there,
Ah.
lordship. So, lordship, they are not in a domestic relation, and the accusation are, there is no specific allegations against the present respondents, your lordship.
Hmm.
Page number,
Yes, this maintenance is for limited purpose, 120. What was the maintenance amount?
main,
But so far, this is more reliefs.
yes, more related
More
included.
reliefs, more reliefs.
More
Relief,
related. That is
18,
that is
19,
right.
20.
There is no bar,
no
no bar is there.
bar.
No bar is there. My contention is that, my lord.
Okay,
That-
Noor Islam Ali, the brother at Orang, and the married sister.
Married sister.
Yes, they have been unnecessarily brought in.
Unnecessary brought in, lord.
Okay, proceedings against them. You cannot go on enlarging the person. Otherwise, general allegation. They do not reside. Where is the scope? Huh? That's, I think Noor Islam and Noor Islam,
4 and 6, your lordship. 4 and 6.
4
your
and
lord.
6.
4 and 6.
And they can be state. Third, Mr. M.J. Quadir, learned counsel for the petitioners, and Ms. S.H. Bora, learned additional public prosecutor for the respondent number 1, State of Assam. Has she appeared in the
Yes, we
other
appear.
case? Other case?
Other case appeared, your lordship.
Okay.
Yes. In the
Any next date?
next date, DB case 6th of February.
No, in the
In
criminal
498.
petition.
49.
No, in the criminal petition. Where is that order?
Oh, criminal, yeah, appeared, lordship, appeared.
Where is that order?
Order page 26, your lordship. Page 26. Already appeared, your lordship.
And where is 498A?
498, I have
FIR?
FIR, your lordship, page number 19 in the petition.
Number 19.
19. 1.
And what did she say that when it was solemnized? 10-6. 10-6 2000.
Yes.
10-6 he left, your lordship. Left.
Ah.
23-10 solemnized.
In this criminal petition under section 528 Bharatiya Nagarik Sureksha Samhita 2023. The petitioners, 16 number, have assailed the proceedings of DB case number 225/2025, presently pending before the court of learned civil judge within bracket junior division number 1-5, judicial magistrate first class, Kamrup M. Guwahati within bracket trial court, instituted by the respondent number 2, full stop, para. Issue notice returnable on so and so. As Ms. Bora has appeared accepted. Respondent number 1. No formal notice. Steps of and respond number 2 by speed post within 3 working days from today. Para. The marriage between the petition number 1 and the respond number 2 was solemnized on 10/6, oh sorry,
2310,
23/10,
2020,
2020.
page 6.
Post of. The respondent number 2 alleging that she had to, due to torture, she was compelled to leave the matrimonial house on 10/6/2021. Post of. The respondent number 2 joined government service on 1/6/2023. Post of. Prior to joining government service, the respondent number 2 instituted a proceeding under section 125 CRPC, FC within bracket criminal case number 188/2022 before the family court Kamrup Metro Guwahati, seeking monthly maintenance from the petition number 1. Post of. The interim, it was interim order.
Interim order.
Okay.
Interim.
An interim order to pay monthly maintenance allowance at rupees 6,000 in FC criminal
Your
case
Lordship,
now.
in the family court, it is final order, sorry.
Okay, a
Final.
final order
So,
to pay monthly maintenance at rupees 6,000 in FC criminal case number 188/2022 has been challenged by the petition number 1 before this court in criminal revision petition number 266/2025. An interim order has been passed on 18/8/2025. Full stop. The impugned proceeding under DV Act, DV case number 225/2025 has been instituted thereafter on
2nd of September, Your Lordship.
2nd of September 2025,
Yes.
and wherein the respondent number 2 has arrayed 6 persons as respondents, including her husband as petition number 1, full stop, in a FIR lodged alleging commission of the offense under section 498A on 12/6/2021, the respondent number 2 as the alleged victim had arrayed the present petitioner number 1, 2, 3,
Yes, yes, Lordship.
3 and
3 and 5.
5 as accused. Full stop. In the said affair, there was no mention of the petition number 4 and the petition number 6.
Yes.
Full stop. The petition number 4 is a brother of the petition number 1, and he is posted presently at Urang National
Yes.
Park.
Yes.
He has been posted in Urang National Park since somewhere
He was initially appointed 2011.
No,
11,
no, before marriage,
before marriage, 2011.
since before the marriage
Marriage.
between the petition number 1 and the respondent number 2.
Oh, yes.
Full stop. On the other hand, the petition number 6 is a married sister of the petition number 1, whose marriage was solemnized much prior to the marriage between the petitioner number 1 and the respondent number
My lord, marriage solemnized after their marriage.
not like it. And is living at a different, living in her matrimonial house
Yes.
in a different place.
Yes, yes.
Full stop. Having regard to such projection, it is ordered in the interim further proceedings of DB case number so and so insofar as the petition number 4 and the 6 are concerned shall remain suspended till the returnable date.
Oh.
6 months.
Problem.
We'll come back.
Item 7.
Yeah, I'm challenging criminal proceeding, my lord, which is pending against me. I'm challenging basically the order dated, framing charge and issuing summon, my lord, and
What is the case about?
case
What is
is,
the complaint case?
my lord, it was converted into complaint case, my lord.
How?
How, my lord, an FIR was lost and it was ended into final report. To that, he has objected, my lord, the informant. Thereafter, it was sent for further investigation. Again, police has submitted final,
Final report.
my lord. Thereafter, he has prayed for converting the it into complaint case. Accordingly,
Okay,
it was done, my lord.
Hmm.
And my contention is that,
One
my
minute, where is the FIR?
lord, FIR at page number
Or
16, my lord.
complaint, same,
Same,
similarly
yes,
worded.
yes, my lord. No separate complaint has been.
Big to kind.
Page 16 is the
Okay.
type code now.
Your cousin?
My lord,
Hmm?
my own cousin, my lord. Regarding two
cousin?
vehicles, yes, my lord.
Okay. Happens to be. Yes, Miss Bora. Emil. Heard, Mr.
H. Ali, my lord.
H. Ali, learned counsel for the petitioner. And Mr. S. H. Bora, learned additional public prosecutor for the respondent state. Full stop. In this criminal petition under
520.
528 BNSS, the petitioner has sought quashing and setting aside of the criminal proceedings of CR case number 22/2024. Presently pending before the Court of Learned Judicial Magistrate First Class JMFC Karbi Anglong Rifu, and an order taking cognizance. Order dated
6325, page 24.
2025, taking cognizance on the complaint for the offense under section 506 IPC. Full stop. Para. Issue notice, returnable on so and so. As Ms. Bora 1, petitioner shall take steps for service of notice upon the respondent number 2 by speed post within 3 working days. Full stop. For proper execution of the issue raised, the appraisal of the records of CR case number so and so will be necessary. So therefore, the scanned copy of the case records of CR case number so and so be called for. Full stop. The respondent number 2. Initially, the respondent number 2 lodged an FIR. Before the officer in charge, Diffu Police Station. And the same was registered as
My lord, Diffu PS case number 144/22.
under section
Under section 406, 420.
420 IPC. Full stop. The investigation resulted in a final report. Number 1 12/2023 on 22/8/2023, right?
My lord,
Or wrong?
my lord, it's 12.
Page. Here put up so and so, so and so, so and so, so and so. Let's see, list. Filed. Oh, no.
Yes, ma'am.
No, no, no.
Page
Wrong,
26, my lord.
Wrong. Wrong.
Page 26, my
Result
lord.
in a final report. Page.
26, my lord.
Oh.
Order
About-
dated 15/6/2023.
2023 on 22/8/2023. Full stop. On notice being issued to the informant, comma. The informant appeared and the court on 28/7/2023 directed further investigation. Full stop. The direction to conduct further investigation resulted again in a final report dated 5/12/2022. Full stop. Thereafter, comma, on the basis of a protest petition, comma, the court of Ladet Judicial Chief Judicial Magistrate Karbi Anglong Difu on 3/9/2024 directed to register a complete case on the basis of the protest petition and full stop. Thereafter, comma, the complaint case, comma, CR case number 22/2024 has been registered. Full stop. On perusal on 6/3/2025, comma, the learned trial court of Judice JMFC First Class Karbi Anglong Difu issued passed the order, impugn order dated 6/3/2025, taking cognizance on the complaint and issued process against the petitioner for committing an offense under Section 406 IPC. Full stop. Having regard to the allegations made in the FIR, comma, it privacy appears that the dispute appears to be of civil nature. Full stop. It is ordered in the interim that further proceedings of CR case number so and so presently pending before the court of JMFC Karbi Anglong Difu shall remain suspended till the returnable date.
Hello.
Has it been framed? Has it been?
There was no case. Absolutely no case.
Obliged.
If he had appeared, I would have cast it today. Unfortunately, he is not here.
Obliged.
Item number 8.
Mother, it's a
Yes.
it's a quashing petition under section 528 for quashing of a CR case which is pending in subdivisional judicial magistrate Bokaghat. My lord, before I come to the grounds, my lord,
Just a minute.
my lord, it's basically a
Just a minute, sir. Who are the petitioners?
petitioner are the,
Petition number one,
is the wife, petitioner.
petition number one is the wife.
Yes,
Petition number two,
is the father of the petition number one. And
okay,
petition number three is Gulshan Khan, who is the brother of the petition number one.
brother of the petition number one.
And there is another petitioner, petition number four, who is the.
Where is the maintain order in DB case?
The order in DB case is, my lord, page number 38, which is a translated version.
38,
Yeah. It's an ex parte decision, my lord.
whatever. 38, complaint case. DB ex parte decision. In case before Itawa. Itawa is in Uttar Pradesh. Uttar Pradesh. Uttar Pradesh. There, the response number two is the petition number or response number one. What is the order passed?
The order pass is 4,000 for monthly maintenance accommodations and 50,000 as a
Which page?
page number 44. ma'am. Page number 43 and 44 opposite.
43, 44. Okay, then the other case, 125,
Then 125 case has been filed, the page number 50, the transit,
page number?
page number 50. ma'am.
Oh, 144 BNS.
145.
What is the order passed?
An expert order, the order has been passed, the operative portion is at page number 56. 6,000
56,
per month.
56. $6,000.
6,000.
Date 15/12/2025. And where is the impugnment proceeding?
This was looking at page number 85. ma'am.
85. Where is Bijnor?
Bijnor is in Uttar Pradesh only, ma'am.
Uttar Pradesh only. What is this proceeding?
No, hello, sir, CR case which has been filed in.
What is family case number?
So, my lord, it's CR 01/25, which is a page, annexure number 7.
No, what is page 70?
Page 70 is an extortion case which have been filed by the respondent number 2's father. It's an extortion case.
What is the complaint?
Extortion case, annexure filed.
No.
Which have been filed by the respondent number 2's father.
When the complaint case was filed? In
Complaint
one.
was filed on 10/1/2025. ma'am.
Just a minute. 10/1,
Page number
2025. Family case. $1,025. Who lost the complaint? Husband.
Husband. Respondent number 2.
Yes, Ms. Bora, Mr. Goswami.
Yes.
Heard Mr.
A.R. Borwa, ma'am.
A.R. Bora, learned counsel for the petitioners. And Mr. M.P. Goswami, learned additional public prosecutor for the respondent number 1, State of Assam. Full stop. In this criminal petition under section 528, Bharatiya Nagarik Surakha Samhita 2023, the petitioners have sought quashing and setting aside of criminal proceedings of
That was
a complaint case, CR case number 1/2025. Presently pending before the Court of Learned Subdivisional Judicial Magistrate, Bokakhat, M. Bokakhat, Trial Court, an order dated 13/3/2025, whereby the trial court has taken cognizance of the offences under section 296, 303 within bracket 2 and section 351 of the BNS, Bharatiya Nyaya Samhita, 2023, and issued process against the petitioners. Full stop. After pre-cognizance hearing under section 223, 2023, full stop, para. The petition number 1 is the wife of the respondent number 2, who is the complainant in CR case number so and so. And their marriage was solemnized on 10/10/2024. Full stop. As discordant disputes started arising, the petitioner number 1 instituted a proceeding, case number 2103/2024, right? Under section 12, Protection of Women from Domestic Violence Act, at a court in Etawah, Uttar Pradesh. Full stop. An ex parte. A final order.
10,
Huh?
11, 20.
Was passed on 10/11/2025, passed ex parte, granting relief to the petition number 1. Full stop. The petition number 1 had also instituted a petition proceeding under section 144B and S before the family court at Etawah, Uttar Pradesh, and the said proceeding, case number 122/2025. In case number 122/2025, a final order was passed on 15/12/2025, granting a monthly maintenance amount of rupees 6,000 per month from the date of filing of the petition. Full stop. The respondent number 2 has instituted the complaint case in the year 2025, which full stop, which the petitioners against all the petitioners, which according to the petitioner is a counterblast to the proceedings initiated by the petition number 1 before the courts at Etawah, Uttar Pradesh, under section 12 DB Act and section 144 BNSS. Full stop. Having regard to the fact situation projected, it is ordered, interim that the further proceedings of so and so presently pending before the court of SDGM M. Bukakhat, CR case number 1 of 2025, shall remain suspended till the returnable date. The scanned copies of so and so case number be called for.
Order is of 15/11.
Issue notice returnable on so and so as Mr. Goswami 1 steps upon respondent number 2 by speed post.
Last order is of 15/11, perhaps.
15/11.
Lordship.
Taking cognizance.
103.
Taking cognizance.
Page number 103.
What is the date?
It is 15/11/24.
15/11/2000.
PWS was issued.
The further proceeding is
Yes.
stay the whole thing is further proceeding.
Time being matter, item number 4.
4.
Net previous year, Lordship.
Ah. Mr. Sharma, you are forest.
My lord, my lord.
Queries for passing of the complaint proceeding arising out of the offense report filed by the
Since
respondent.
you are already enjoying a stay order, we'll pass an order.
I mean,
We'll issue a notice.
My lord.
Let it be tagged with
yes,
Yes,
my
my
lord.
lord.
other case.
That is fixed on 26th of February, my lord.
And my lord, the scan copy
Of this instant
Yeah.
criminal proceeding.
may be called.
Heard Mr. G. Jalan, learned counsel for the petitioner. And Mr. B. Sharma.
For respondent number 2, my lord.
Respondent two.
My lord.
Okay, MP Goswami, learned additional public prosecutor for the respondent number one, state of Assam. And Mr. B. Sharma, learned
Special PP wildlife.
special public prosecutor wildlife for the respondent number two. Full stop. The proceedings of CR within bracket F, case number 04/2025, 4, comma, presently pending before the Court of Learned Chief Judicial Magistrate Lakhimpur, not Lakhimpur Trial Court, has been put to challenge in this criminal petition under section 528 B and SS. Full stop. Where the petitioner has questioned the proceedings initiated by the Forest Department, Assam, on the ground of territorial jurisdiction.
Interspectator jurisdiction. Dispute,
In-
boundary dispute.
On the ground of territorial jurisdiction to investigate into the offense, as according to the petitioner, comma, the offense, alleged offense, had been committed in a disputed territory. So according to the petitioner, comma, the alleged offense had occurred within the state of Arunachal Pradesh. Full stop. The petitioner issue notice returnable on so-and-so as Mr. So-and-so appeared accepted 1 and 2, No formal notice is not necessary. The scan copy of the case record of CRF case number so-and-so be called for from the trial court. Full stop. It is noticed that it has been, it is, full stop, in criminal petition number 1037/2025, wherein the petitioner herein is the petition number 1. Come on, this court has already issued a notice to the respondents with an interim order on
This 42.
26/8/2025, suspending further proceedings of another complaint case, CR within bracket F case number 15/2023,
Pertaining to same land.
pertaining to the same,
Same land, man.
Same
Same land. It is the same land, man.
Same?
Plot of land.
Pertaining to the same,
What same issue?
pertaining to similar issue. And the said criminal petition is ordered to be listed on
26th of February.
26th of February 2025. Issue notice 26th of February. 26/2. Where having regard to the similar issue and the interim order passed therein, comma, it is observed that further proceedings of so-and-so case number shall remain suspended till the returnable.
For admission, item number 9.
I pay 20 motion.
We have filed criminal petition for quashing the proceeding of GR case number 2330/2012 pending before the SDGM and Borpeta.
Whether that carrying of PDS rice,
Yes, Lordship.
PDS rice is in discharge of official duties or in purported discharge of official duties. That is a matter which is tribal. And this, in a criminal petition, this kind of resolution taken by the society is not to be gone into.
Resolution taken by the SMC Lordship.
No, this material is not to be gone into. This is a matter of trial. And this can wait. Prosecution can wait. Sanction can wait.
So Lordship,
Wait one year.
a resolution is superior to the filed by the FIR Lordship.
No, this,
That's why Lordship.
right, what is the, can you introduce a document in a criminal petition? Yes, it can be introduced, but it must be of unimpeachable character. And this is not this kind of document, and veracity, correctness of this kind of document is not to be gone into. This alleged misappropriation of PDS rights.
Yes, Lordship. But
This is a matter which is to be
Lordship.
adjudicated in a trial.
Here is the petitioner Lordship.
This harassment is, what is the scope of interference in 528 or 482? Right from RP Kapoor to Bhajanlal to whatever latest order passed. Whether anything, any document placed by accused can be gone into. Yes, it can be gone into in some cases where the document is of unimpeachable character.
On the strength of that document, Lordship, it has been stated.
On the strength of that, I don't know for what reason. It is stayed for last 9 years.
9 years now. But in this case, Lordship, as per the resolution petitioner was.
So without any discussion on merit,
No.
at least privacy,
No.
no reason,
No.
simply state.
Right.
Charge-sheeted case.
And charges
That
are also,
prosecution sanction is required.
charges are also framed, madam.
Charges are also framed. Yes, what is that? It can be looked into. Hey, Hansal. Hey, CRPC, Hedicon, a digest come.
In resolution itself stated that petitioner is.
Resolution, sir, resolution cannot be gone into. If you can establish it during trial, that sanction was a necessity, then it can be terminated. But at this stage, no. But 197 করে আছে।
190.
PK প্রধান। PK প্রধান। হ্যাঁ। Peter Roxon. Yes. In this criminal petition under section 482, 1973, the petition has sought quashing and setting aside of a first information report dated 14/8/2012, registered as Colgasia Police Station case number 256/2012, semicolon, 1 করে দিব, a charge sheet dated 8/12/2015, laid in that connection, and the proceedings of corresponding GR case number 2330/2012, presently pending before. I don't know it is pending or not. Pending before the Court of Learned Subjudicial Magistrate, Subdivisional Judicial Magistrate, within bracket S Borpeta, trial court for short. Full stop. Para. I have heard Mr.
A. Alim Sheikh Lordship.
A.I.
A. Alim Sheikh.
Sheikh, Learned Counsel for the petitioner, and Mr. M.P. Gupsami, Learned Additional Public Prosecutor for the respondent state. Full stop. Ordinary process. Interim order. None has appeared. For the respondent number 2, despite service of notice. Full stop. Vera. The respondent number 2, as the informant, lodged a first information report before the in charge, Borbita Police Outpost on 14/8/2012. Also, in the affair, the petitioner, who was then serving as the superintendent of Langla Senior Madrasa, was named as the accused. Full stop. The petitioner, as Superintendent Langla Senior Madrasa, is a government employee under the Directorate of Madrasa Education, Government of Madrasa Education, Assam. Government of Assam. Full stop. Para. In the affair, it was interiorly alleged that at about 11 a.m. on 14/8/2012, 7 number of what? Bosta English? Sack. 7 number of sacks containing PDS rice was being transferred. PDS rice meant for midday meal. Sorry, allotted for midday meal scheme, was being transported from Langla Senior Madrasa by way of a cart in order to sell them in the open market. Full stop. The informant and other members of the student union of Borpeta Bongaigaon College intercepted the cart whereby the midday meal rice was being carried. Full stop. It was alleged that it was the petitioner the superintendent of Langla Senior Madrasa had directed to take out the rice that meant for midday meal scheme to sell in the open market. Full stop. On the basis of the affair, Colgacia Police Station, case number 256/2012, was registered for the offences under section 406/409 IPC on 15/8/2012, and the matter was investigated into. Full stop. The IO, after completing investigation into so-and-so case number, submitted a charge sheet under section 173(2) CRPC. White charge sheet number 40/2015 on 8/2/2015, finding a prima facie case established against the petitioner to proceed under section for the offences under section 406/409, against to proceed for the trial. Full stop. Para. On Thursday, Mazuli corresponding GR case number 2330/2012. Para. In the course of investigation, the petitioner was arrested and thereafter the petitioner sought the benefit of pre-arrest bail before this court and this court by an order dated 12/9/2012 passed in AB number 3470/2012, extended the benefit of pre-arrest bail under section 438 CRPC on the ground that in view of the projection made by the petitioner that the rice bags were sent back to the Godam of a cooperative society since Langla Senior Madrasa was closed during the relevant period. Full stop. Para. On submission of the charge sheet, comma, the case was transferred to the Court of Learned Subdivisional Judicial Magistrate as comma Barpeta for disposal. Full stop. The petitioner, on receipt of summons, comma, the petitioner appeared before the trial court, on 6/3/2017, and on a prayer being made, comma, he was allowed to remain on previous bail. Full stop. After taking cognizance the trial court. Charge frame when? Framed. After hearing the learned counsel for the parties, comma, the trial court. Framed. Charge 24/6. Where is the charge framing order? Where is the charge framing order? Huh?
It's 33.
33. Frame charges under section 406 and section 409, under sections 406/409, comma, IPC. Against the petitioner on 10/4/2017. Full stop. The petitioner pleaded not guilty and claimed to be charged, claimed to be tried. Full stop. Thereafter, comma, the trial court directed to issue summons to the prosecution witnesses. Full stop. It was at that stage, comma, the petitioner has approached this court by the present criminal petition. Full stop. The ground raised by the petitioner is that the petitioner, comma, at the relevant time, comma, was serving as a government employee and a sanction for prosecution under 197 CRPC was a condition precedent for the trial court to take cognizance of the offense. Full stop. As there was no prosecution sanction, comma, the trial court would not have taken cognizance and would not have taken cognizance to proceed further with the proceedings of GR case number so and so. Full stop. To support such contention, comma, the petitioner has referred to a resolution taken in an executive meeting of Langla Senior Madrasa on 22/7/2012. A resolution, comma, resolution number 1. Full stop. Para. I got, comma, annexed as annex 2 to the instant petition. Full stop. As per the resolution, as per resolution number 1, taken purportedly in a an executive meeting of Langla Senior Madrasa held on 22/7/2012, the executive body resolved that even after feeding midday meals to the students, 7 sacks of midday meal rice sanctioned on 27/5/2012 had remained unused. Full stop. As rats stroke mice had started infesting the same, there was a possibility of the rice, there was a possibility of the MDM rice being damaged in view of the long vacation in the madrasa. Full stop. The executive body appeared to have taken a resolution suggesting the superintendent of the madrasa, that is the petitioner, to deposit the 7 bags of MDM rice to Uttar Pani Cooperative Society and to bring the rice bags back from the Cooperative Society after reopening of the madrasa. Full stop. The superintendent was thereby entrusted with the responsibility of exchanging the bags of MDM rice with the chairman of the Cooperative Society. Full stop. Para. In a criminal petition, and the law is settled that in a criminal petition under section 482 CRPC, a document referred to relied upon by the petitioner, which is not part of the investigation, or which is not part of the investigation in the charge sheet and stroke or the charge sheet, cannot be relied upon ordinarily. Full stop. Only in exceptional cases where the document introduced by the petitioner is of unimpeachable character, the same can be referred to. The same can be taken into consideration. Full stop. Para. Section 197. Or records are same, huh? Ah. And therefore, the documents relied upon by the petition in the form of the proceedings of the executive committee of Langla Senior Madrasa cannot be termed as one which is of unimpeachable character to be, and no reference can be placed. No, and such document cannot be taken into consideration while deciding, while considering the challenge, while considering a criminal petition seeking quashing and setting aside of the entire criminal investigation and proceedings. Post of para section 197. Within bracket 1. Section 197. Section 197 within bracket 1 and section section 197 within bracket 1 and within bracket 2 of the Code of Criminal Procedure 1973 CRPC or the code read as under. The provisions of section 197 deal with the condition requisite for initiation of proceeding. And it is mentioned that if the conditions mentioned therein are not made out or are absent, then no prosecution can be set in motion. Full stop. A jurisdiction of a magistrate to take cognizance of any offense is provided by section 190 of the code, either on receipt of a complaint, or upon a police report or upon information received from any person other than a police officer, or upon his knowledge that such offense has been committed. So far as public servants are concerned, the cognizance of any offense, by any court, is barred by section 197 of the code, unless sanction is obtained from the appropriate authority, if the offense, alleged to have been committed, was in discharge of the official duty or in purported discharge of the official duty. Full stop. Use of the expression, quote unquote, official duty goes to indicate that the act or omission must have been done by the public servant in the course of his service, and it should have been in discharge of his official duty or purportedly in discharge of his official duties. Full stop. The section does not extend its protective cover for every act or omission done by a public servant in service, but restricts, and its scope is limited to only those acts or omissions which are done by a public servant in discharge of official duties. Full stop. In K. Kali Mathuf versus State, the Supreme Court has observed as under paragraph 11. where the protection under section 197 has certain limits and is available only when the alleged act done by the public servant is reasonably connected with the discharge of his official duty and is not merely a cloak for doing the objectionable act. If in doing his official duty, comma, he acted in excess of his duty, comma, but all right. Before section 197 can be invoked, comma, it must be shown that the official concerned was accused of an offense alleged to have been committed by him while acting or purporting to act in the discharge of his official duties. It is not the duty which, no, it is the quality of the act or omission which is important, and the protection of this section is available if the act falls within the scope and range of his official duty. There cannot be any universal rule to determine whether there is a reasonable connection between the act done and the official duty, comma, nor is it possible to lay down any such rule. One safe and sure test in this connection would be to consider if the omission or neglect on the part of the public servant to commit the act complained of would have made him answerable to the charge of dereliction of his duty, colon. If the answer to this question is in the affirmative, comma, it may be that such act was committed by the public servant while acting in discharge of his official duty, and there was no connection with the act complained of and the official duty of the public servant. Within bracket, REF, Rakesh Kumar Mishra versus State of Bihar. It is appropriate to refer to the following observations made in P.K. Pradhan for the state of Sikkim. Era 16, 15. It is a well-settled proposition that question of sanction under section 197 of the code can be raised anytime after the cognizance, semicolon, may be immediately after cognizance or framing of charge, or even at the time of conclusion of trial, and after conviction as well. Full stop. But there can be cases where it may not be possible to decide the question effectively without giving opportunity to the defense to establish that what he did was in the charge of official duty. Full stop. In order to come to the conclusion whether a claim of the accused that he had sent the 7 bags of MDM rice, which were meant for midday meals midday meal scheme rice, which was meant for the students of senior Langla Senior Madrasa, comma, to the to a place outside the premises of Langla Senior Madrasa, purportedly in pursuance of resolution of the Executive Committee of Langla Senior Madrasa, was in course of performance of his duty, was a reasonable one, can be examined during the course of the trial by giving opportunity to him to establish it. Full stop. In such an eventual as the position, as the resolution, as the acceptance of, or otherwise of the as the existence or otherwise of the minutes of the proceedings of the Executive Committee of Langla Senior Madrasa, and for that matter, the resolutions adopted therein are not matters which can be gone into in a criminal petition under 482 CRPC. The question of section should be best left open to be decided by the trial court in the main judgment which should be delivered upon conclusion of trial. Full stop. The claim made by the petitioner that the bags of MDM rice were sent outside the premises of Langla Senior Madrasa in sending. He did not abuse his position as a public servant. Are required to be established during the course of the trial. Full stop. Therefore, it is not possible to extend any relief to the petitioner at this stage. Full stop. Observing that during the course of the trial, the trial court shall examine the question afresh and deal with the same in the course of the trial or in its main judgment in the light of the law laid down, in the light of the settled propositions, this criminal petition stands dismissed. So you have the liberty, you say that this resolution was, produce those documents, then exhibit it thereafter. The interim order passed earlier stands accordingly recalled.
Number 10.
Your Lordship, kindly to matriculated by the day.
Possible for a day?
Sir.
Okay, any request? Made on behalf of the petitioner by Ms.
R. Chaudhary.
R. Chaudhary, Learned Counsel Board of Petition.
For response number 2, date may be fixed, Lordship.
And with the consent of Mr.
D. Kolita.
Learned Counsel for the respondents.
Response number 2.
To release the case on. Next, today is what? Wednesday?
Wednesday.
Next Wednesday.
Your Lordship, interim shall continue.
Interim order passed earlier, shall continue till the next date of listing.
Obliged.
Item number 11.
There's a compromise between the parties.
Hmm?
There's a compromise between the parties, my lord.
Ah,
Already I have filed an affidavit, but it is not taken a record.
okay. Compromise arrived at.
My lord,
Okay. Learned Mr.
M. Hendik,
M. Ali
M. Hendik.
Hendik, learned counsel for the petition, has submitted that a compromise has been arrived at by the parties. What kind of compromise? This is a transfer petition.
My lord, this is a agreement between the parties.
Okay,
Therefore,
about what?
Petitioner,
About what?
my lord, the complainant is agreed to withdraw this main petition, my lord.
Huh? Oh, the petitioner
My lord.
has been arrived at, and to that effect, comma, an affidavit has been submitted, has been filed,
My
has
lord.
already been filed when?
Already filed yet. Yet it is not taken, my lord.
When did you
My
file?
lord, 19/1/26.
On 19/1/2026, first of. As the said affidavit is not on record, comma, the learned counsel for the petitioner has sought listing of the case on Friday with the said affidavit on record. List the case accordingly on so and so. Interim of the past trial shall continue till the next date of listing.
3001. Item 12.
May I please, Your Lordship?
An application for challenging your judgment of the additional in criminal appeal by which has been ordered passed by the plan, so in this case has been upheld. You need to pay monthly maintenance order. Take steps. Yes.
Lordship, initially my wife, Lordship, had filed a
Where is Mr. Nawaz, Mr. Das Rahman for response number 2? Their names are there.
I have seen.
Names are there.
Yes, Lordship. He was
Date
there
of-
sometimes,
Huh.
but present-
So what is the case about?
my wife had, Lordship, filed an application, Lordship, in the year 2012, Lordship. And in this,
Judicial magistrate first class.
yes, Lordship. Wherein, Lordship,
Maintenance petition.
maintenance. That is
DV.
DB Act under
Huh?
section 20. And in that case, Lordship, 2,000 rupees was awarded for my wife and 1,000 for my child. And in the year 2019, Lordship, enhancement petition was filed. And in the enhancement petition, Lordship, it has been increased to 9,000. Thereafter, we filed appeal. Appeal was dismissed. And against the appeal, we have filed this report.
What is the illegality, impropriety or incorrectness?
Lordship, kindly see. Page 25,
Let us find out first the
Lordship, I am
trial court order.
filed
Trial court order.
page 38.
Page 38.
Okay. This is the
Okay.
enhancement order.
Page 38.
It starts from page
Just a
40.
minute, just a minute. CR case number 5, 12. So initially 2,000 and 1,000,
Yes, Lordship.
hmm?
Yes, Lordship.
Along with some other reliefs.
Yes.
At that time, it was contested, challenged,
Yes, Lordship.
challenged,
Challenged.
dismissed.
No, Lordship, that what was, we have not
Okay.
challenged.
Then thereafter,
Enhancement petition was filed.
the enhancement petition 25. Enhanced maintenance.
Yes.
Okay, 2012, it is 2,000 and 1,000. Right. Then trial court enhanced the amount to 5,000 and 4,000.
Yes, Lordship.
When your child was born,
My child was born, Lordship, on 5/7/2011.
5/7/2011.
Yes, Lord.
So he or she, son.
Son.
So he would be appearing in matriculation
Yes, Lordship.
very soon, I think.
Yes, Lordship.
Right?
Yes, Lord.
Okay, then you preferred appeal.
Yes, Lordship.
Appeal is dismissed.
Yes, yes.
Okay. And you, what do you do?
Lordship, I'm a Mohori under a contract, Lordship, private.
Rich person.
Mohori Lordship. Just I look after the works of a contractor. Lordship.
Mohori, all Mohoris are very powerful. Yes,
Lordship, kindly see the
and rich and influential.
Lordship, kindly see the my
Let us see the reasoning.
Lordship, page 25 may be seen, Lordship.
Page 25 may be
The
seen.
petition.
Okay.
Second, page 26.
Firstly, that lady does any work?
No, my lord.
No, unemployed.
Unemployed.
Lordship,
Any educational qualification? No. Okay. Final order. Listed first class. Minor son. Responsibility maintainable is a Mohori. Mohori under a contractor in the PWD department.
Yes.
And contractor carries on government contractual work in various places.
He was also examined as DW2 in enhancement petition, Lordship.
I thought he resides at Guwahati in a rented house. Oh, you have second wife?
Yes.
Second.
Happy Kids School, Panjabari.
Lordship, their enhancement petition may be seen, Lordship, page 26 relevant question.
In case where a son, namely class 2 golden daffodil, unable to carry out the nominal amount, it is stated that the son is around promoted to class 2019. 2019, he was in class 5.
Yes, sir.
So now at what class?
Is about to appear for his matriculation as per my instruction.
Increase in the register farmer for our son. No divorce.
No.
Oh.
Lordship, basically they have filed this enhancement petition that Lordship, he has been enrolled at Golden Daffodils Academy, a private English medium school. My son has been pursuing his studies in private schools, Lordship. Private school. And list of expenditure also mentioned in page 26. Page 26.
Where your children from second wife studies?
No, Lordship, I'm first wife, Lordship.
No, second wife, that is there in the order, my lord. Happy Child School, my lord.
One.
That-
This responding is first wife or second wife?
That's only first wife. First wife and son.
At page 43, it is specified.
Golden daffodil, golden daffodil.
So far our information, Lordship, he is running some business, Lordship. But we have no evidence, Lordship, but he is running.
Then no point.
But kindly see the Lordship.
Other states during the pandemic tried.
My son was admitted in a private school, Lordship.
Whose son?
My son, Lordship. First from first wife. First wife. First. List of expenditures given in page 26. Here monthly expenditure was shown as 3,678.
Your employer is what class of contractor?
Yes, Lordship.
He
Page 36.
did not depose.
Depose, Lordship. Page 36.
What did he say?
Lordship, kindly see page 36.
Tell me.
I know the respondent. He
What
was-
class of contractor? PWD contractor, I know. What class of contractor?
Lordship, that is
That has
Not there.
not specifically mentioned. I am a PWD contractor. Just mentioned I am a PWD contractor. Under PWD department.
It is a contingent due to. What is your ground of challenge?
Lordship, my income has not been ascertained, Lordship. The
You are
respondent-
able-bodied man of,
Lordship, I have mentioned, Lordship.
you are
my-
able to
my
maintain two families.
Lordship, employer says that I am.
Tell me,
receiving
what is
8,000.
the cost you think reasonable for a son who is to appear in a matriculation examination very soon?
Lordship, he is pursuing in private schools. So why require, Lordship, private school? There are so many government schools there, Lordship. And expenditure shown as 3,000.
Ask the government to make the public institution good enough to take admission. Who does not want better education?
The condition is.
You as a
my
father,
financial condition.
you as a father should want better education for your children.
Definitely.
Hmm?
By
That so
condition
that
should
he should
go-
not be a burden for you in future.
So, Lordship,
And
I
how
not
old
been-
are you?
He's
How old
44
are
now he
you?
will be 44, my lord.
44 only.
In fact, the second wife's son, my lord, he is also studying in an English medium school.
Hmm.
At least he should balance it out.
Lordship.
Same status. Same status. Where your son from second wife studies? Tell me,
Lordship.
DPS,
No, Lordship.
Sanskriti Gurukul,
No, no.
Happy Kids
Happy
School, my lord.
Kids School in
Panjabari,
Punjab.
Guwahati.
huh? Panjabari Guwahati.
Happy Kids.
And this boy studies in the Daffodils.
Therefore, this.
Huh. Is there any scope for enhancement in a petition
Look,
seeking this,
enhancement, Lordship.
seeking,
Lordship, 3,000.
making challenge to enhancement?
Lordship, 3,000 has been enhanced to 9,000, Lordship. They paid for 12,000.
7.5 years.
Well, Lordship.
That
condition
is,
my-
that too in 2017. And final order was passed.
In this case, my lord,
Final order was passed.
on
425.
3/1/2025.
The enhancement is on the lower side.
So some amount may be reduced, Lordship. I am not denying he's not entitled. They are not entitled, Lordship.
That fact
Some-
is clear
some-
that your son from second wife reads in private school. So it
We
has to
have
be
to
same
maintain,
yardstick.
Lordship. At present, I have been maintaining 2 families, Lordship.
Good. You are
So
capable
that's the
of,
problem, Lordship.
that is why you are capable of, that is why you have entered into
Lordship, my
second matrimonial relationship. Right?
my employer.
Who has told you not to enter? Who has told you? You? On your own, thinking that you are capable of maintaining 2 families, 2 sons, 2
Lordship,
wives.
I have left
Good enough.
no option other than married to second marriage, Lordship. He left her.
No, you have not. Have you sought any divorce?
No, Lordship.
No. So you are capable of maintaining 2. That is why you have not sought divorce. No, marriage.
So, Lordship, some amount. may be
5,000 and
reduced.
4,000 is quite enough. Had there been scope to enhance, I would have enhanced it.
The amount is very high, Lordship.
Can we impose cost more for bringing the lady and her son to the court again? You should have stopped it at the appellate court itself. Heard Mr. A.T. Sarkar. I don't find any merit. Learned counsel for the petitioner. Who is there? Mr. R. Kaushik, Learned Additional Public Prosecutor for the respondent number 1, State of Assam, and Mr. S. Nawaz, Learned Counsel for the respondent number 2, Rustam. This criminal revision petition under section 438, read with section 442, Bharatiya Nagorik Surakha Hanita 2023 is preferred to assail a judgment dated 4/8/2025 passed by the Court of Learned Additional Sessions Judge number 2, Nagaon, Assam, within bracket appellate court, the appellate court for short, in criminal appeal number 06 within bracket capital N 2025. Full stop. By the judgment dated 4/8/2025, comma, the appellate court has dismissed the criminal appeal preferred by the revision petitioner as an appellant against a judgment and order dated 3/1/2025 passed by the Court of Learned Judicial Magistrate First Class, Nagaon Trial Court for short in Miss Case number 54/2019. Full stop. Para. The effects, comma, in brief, comma, leading to the institution of this criminal revision petition can be stated as follows, comma. The marriage between the revision petitioner within bracket hereinafter referred to as the petitioner for short and the respondent number 2 hereinafter referred to as the respondent for short was solemnized. When? In the year
2010, madam.
2010. Post of. Out of the marital relationship, comma, a boy child was born to them when
5/7/2011.
5/7/2011. Post of. Due to discords and disputes, comma, the respondent with her son, started to reside separately from the petitioner since the year
2012.
2012. Full stop. In the year, comma, 2012, comma, the respondent wife instituted a proceeding, comma, CR case number 2108/2018 for 12 under section 12 of the protection of
Protection of women from domestic violence.
deviate against the petitioner and other in-laws seeking various reliefs, alleging commission of domestic violence upon her. Full stop. Upon adjudication, comma, the learned court had granted maintenance allowance of rupees 2,000 per month to the respondent wife and rupees 1,000 to her minor son, along with some other reliefs under section 18, section 19 and section 20 of the DV Act. Full stop.
22 is also there.
Huh?
22 is also there.
Okay, section 22 of the DV Act. Full stop. The situation rested in same position for a period of about 7.5 years. Full stop. Para. It was in 2019, comma, the respondent wife preferred another application under section 25 of the DV Act against the petitioner husband seeking enhancement of the maintenance allowance. Full stop. The said application was registered and numbered as Miss Case number 54/2019 before the Court of Learned Judicial Magistrate First Class JMFC, Nagaon, the trial court. Post of. In the proceedings of Miss Case number 54/2019, the respondent wife adduced evidence herself as PW1, and the petitioner husband adduced evidence of two defense witnesses. Full stop. The trial court, upon perusal of the materials brought on record and after hearing the parties, dispose of the petition for enhanced compensation by judgment and order, by a final order dated 3/1/2025. Granting enhanced maintenance allowance at ₹5,000 per month to the respondent wife and at ₹4,000 per month to her son. Post of. The petitioner husband was directed to pay the above maintenance allowance from the date of the application. Post of. Para. Agreed by and dissatisfied with a final order dated so and so. The petitioner husband took the matter in appeal to the appellate court in criminal appeal number 06/2006 within bracket 9/2025. Full stop. The appellate court, finding no merit in the appeal, dismissed the criminal appeal, thereby affirming the final order passed by the trial court. Full stop. Hence, the present criminal division petition heard Mr. A.T. Sarkar, learned counsel for the petitioner, and Mr. Otukoluetu. Full stop. It is the contention of the petitioner that the enhanced maintenance allowance granted by the trial court and affirmed by the appellate court to the respondent wife and her son are on the higher side. Full stop. It is submitted that the petitioner is working as a Mohori within bracket class 1 under a class 1A contractor. Page 21. Nazrul Islam, DW2.
Yes, sir. No.
DW2,
DW2 is not a person, my lord.
who undertakes works, who executes works under the PWD within bracket Roads Department, Government of Assam.
DW2's name is Girikanto Bora.
Huh?
Girikanto Bora.
Then why to page 21? P respondent 1 himself admitted that he is serving as a Mohori, Nazrul Islam.
But here in evidence, he brought in Girikanto Bora as a contractor.
He was earlier another contractor. Thereafter, he
Story, Mr. Sarkar is now manufacturing the story.
No.
Okay, PWD, now no nalage. And when the earlier before the trial court, in CR case number 2008, he admitted to that effect. Full stop. It is not in dispute that the respondent wife is the first wife of the petitioner. Full stop. After the petitioner and the respondent started residing separately, the petitioner entered into matrimonial relationship with another lady, and out of the said wedlock also a child was born. Full stop. The boy child is also presently pursuing studies in a school. Full stop. Para, the contention of the petitioner that the enhanced maintenance allowance allowed by the trial court and affirmed by the appellate court are on the higher side is found to be one. No, not like it. Line continue. While seeking enhancement of the maintenance allowance, comma, the respondent's wife in 2000 in the petition application had inter alia stated that at that point of time, comma, her minor son stated that when earlier maintenance allowance of rupees 1,000 to her minor child was granted, the minor boy child was about 1.5 years old. And in the year 2019, comma, he became 8 years old and was studying in class 2 at Golden Daffodils Academy, comma, a private English medium school located at Potodrova, Nagaon. Full stop. The respondent wife had projected that there was the enhanced the maintenance allowance should be increased appropriately, as the expenditure of her minor child was about monthly school expenditure of the minor child was about rupees 3,678. So due to such expenditure, the respondent wife was unable to maintain herself and her minor son with the maintenance amount of rupees 3,000. Full stop. Earlier granted in the year 2012. Full stop. Para, it has emerged that the petitioner husband is presently staying with his second wife and his minor boy child who is studying at Happy Kids School at Panjabari, Guwahati. Full stop. The contention, the submission advanced by the learned counsel for the petitioner that the enhanced monthly expenditure for the minor child of the first wife has arisen, the claim for enhance has arisen due to his admission in a private school deserves to be rejected on the ground that, primarily on the ground that the minor boy child of the petitioner from his second wife is also presently pursuing his studies in a private school at Guwahati. Full stop. The trial court as well as the appellate court has taken into consideration the rising cost of living and increased and constantly rising education expenses amongst other factors to reach a finding that the enhanced maintenance amount of rupees 4,000 would be reasonable, as such enhanced claim was made after 7.5 years from the earlier order of maintenance,
Not the earlier order, earlier application. Order was last subsequent.
earlier application
Date of birth.
on maintenance. Full stop. The respondent wife, who is the first wife of the petitioner, has a right to live in a condition which is of the same standard as the petitioner is presently living with his second wife and her minor child. Full stop. The petitioner, who has claimed to be serving as a clerk under a contractor since what is the first judgment?
First judgment, Your Lordship will find it page 14, my lord.
Page?
That relevant portion, page 14.
Page 14. From 2018. And presently earning what amount?
He claims
9,000.
8,000.
8,000. Has been found
Finding to that effect, Your Lordship will find at page 49, my lord. Trial court judgment.
has found non-acceptance was not accepted by the trial court as well as the appellate court, as the petitioner husband had failed to lead reliable evidence on that count. Full stop. The petitioner, aged about
44 now.
44 years, presently aged about 44 years, and is an able-bodied man, comma, is duty-bound to maintain the first wife and her minor son, who is full stop. It is the petitioner has not till date, comma, the petitioner has not sought dissolution of his marriage with the respondent wife. Full stop. The minor boy child from the first wife, respondent's first wife, is presently studying in is presently studying in
Class 9.
is presently studying in class 9, and as such, comma, and the maintenance allowance of rupees 4,000 per month is found to be reasonable in view of the rising cost of living and educational expenses in the present scenario. So similarly, comma, enhanced maintenance allowance of rupees 5,000 granted to the first wife of the petitioner, respondent wife of the petitioner, is found to be reasonable on similar grounds. Full stop. Para. In granted by the trial court in the judgment, in the final order dated P1 2025, in Miss Case number 54/2019, which was decided after a period of 6 years from 2019, is found to be regional and just and deserves no interference. But in view of the above discussion, the present criminal revision petition is found to be lacking in merit, and the same is dismissed.
Item 13.
My lord, this matter may be passed over for the day, lordship.
For the day.
For the day.
My lord, in this case, my lord, I am praying for bail, and the petitioner in jail for last 309 days.
Lordship.
And here I have raised only purely question of law, my lord. Even in absence of my friend, it can be decided, but because it is a question of law, nothing on fact.
Okay, when do you want? Monday?
Lordship.
Monday, my lord, I am praying for bail.
On the earlier
And
date?
your lordship kindly peruse the last order, my lord. It was the court, honorable court held that in absence.
That day you were not present.
Only within it is 30 seconds, my lord, I have missed this item. I was
Whatever.
just there.
Whatever,
I was very much there in the court.
whatever, it has been reflected.
Yes, that was unfortunate because
Okay. You are for whom?
I'm for the respondent number 2, Lordship.
Who is he?
The
Who is he? In what capacity? POXO?
I am a accused in the POXO case.
the informant, Lordship.
Asadul Islam.
Here the question of law is that, my lord. The case was initially registered under POXO.
No, it is after conviction or what?
No. At the trial stage, I have order, telling the framing of order, my lord. The order of framing charge, this order. Initially, the case
No,
was
1
registered.
minute, 1 minute. The proceeding is still pending.
Yes.
Now, in what manner in a criminal revision petition you are seeking bail?
Bail is in IA. The petition is
No. Criminal revision petition is against what order?
order of framing charge.
Then how can you seek bail in such a criminal revision petition?
Therefore, my lord, I have submission, unless I submit your lordship. my lord,
No, bail can out of question in a criminal revision
bail,
petition.
your lordship.
It is only suspension of sentence. No, don't waste time making submission
in
on bail.
Petition, the court has the jurisdiction to grant bail on the basis. That is, I will have to make out my case, my lord.
No,
It
first you point out, don't make submission.
Yes.
On what authority you are making submission?
Yes. This petition is filed.
No, regarding bail.
Yes, your lordship will find the 438.
438 cannot be granted.
Revision is filed under 430 as BNSS. This is revision, provision.
Okay.
This court can suspend, fine.
Suspend what?
Therefore,
That is the question.
438.
438.
38. The High Court or any session judge may call for and examine the record of any proceeding.
Correct.
Yes.
That is, I am
Before
not doubting.
any inferior criminal court situate within its or his local jurisdiction for the purpose of satisfying itself or himself is the correctness, legality or propriety. I have challenged the legality of the order of framing charge.
And direct.
And propriety of any
Execution.
finding, sentence, finding, comma, your lordship, finding, comma, sentence or order, recorded or passed, and as to the regularity of any proceeding of such inferior court, and may with, when calling for such record, direct that the execution of any sentence or order be suspended.
Sentence be suspended.
Or order.
Order
Or
is
order.
not for bail.
No, your lordship,
I am dismissing, you go to the Supreme Court.
your
Don't
lordship,
make such
your lordship may
I
dismiss
do.
my IA, but I am still.
I am dismissing the IA, you are making submission on it. Don't try to take the court for a ride. Which order impugned you have? Where is the question of suspension of sentence when the proceeding is not there?
I have not, this is not a question of suspension, my lord. Your lordship, once again, I have not completed my argument submission, my lord.
Okay. Okay, you wait. If your presence
Such
is
record or direct execution of any sentence, calling for such record or
Okay,
direct
let us come to
execution
the
of such
main
sentence
criminal petition.
or order, your lordship.
Okay, since you are insisting for hearing, let us come to the main criminal petition.
Yes.
Everything will be, yes, Ms. Bora and Mr.
This
Kaushik.
is a pure question of law.
You provide assistance.
Your lordship may decide either way because the matter is pending. I am in the jail for last more than 3 hours.
He made a prayer. I thought that I should allow his prayer till Monday.
Because had he not been in jail, my lord, I would have not object his prayer. Because I am
The
in jail for
counsel
last.
should be at the same time reasonable. On the previous date, you were absent.
No, it was, my lord, very much because.
No, I don't know.
No.
Please proceed.
Your lordship kindly in the FIR. Page 33.
Yes.
Page 33, last part, my lord. The medical report. Last, my lord, 1, 2, 3 paragraph. I have got it. The medical report of the victim has been page 33. the medical report of the victim has been collected. Yes, it is not acceptable. You reinvestigate the matter. Or I will take it as a complaint case. I will take evidence. That has not been done. And therefore, in not doing so, and in remitting the case to the special court with direction, 507 comes one, earlier 461. The entire proceeding is vitiated.
Okay.
507, your lordship, for a moment, kindly. 507L. Tries an offender. Irregularities which vitiate proceedings. There are two lists, my lord. 506, earlier 460, has given a list where irregularities does not vitiate proceeding. Now it is 506. And 507, earlier 461, has given a list where irregularity vitiate proceeding. Now, in 507L, your lordship will find tries an offender. So my humble submission is there. When police has not submitted charge sheet under POXO, how a POXO court can take cognizance and try the case? And the
Whether the BNSS equates a magistrate with a session judge?
the session judge power is
No, I'm asking.
no.
Huh?
Only in respect of my lord power.
Whether magistrate is same as session judge?
No, normally charge sheet is submitted to the magistrate when there is a session.
Because no, once 507 it speaks about magistrate.
No, there is no any other provision. So what magistrate in my humble submission, your lordship may subject to it is your lordship domain whether it is acceptable or not. But here my understanding is that, my lord, that here the all trial courts are indicated because tries an offender.
But it is preceded by the word magistrate. That is why.
In so many, your lordship, going by the CRPC, there are so many words, magistrate and court. In time and again, in various occasions, Supreme Court and this High Court has held, court means all court. Sometimes court means High Court. Sometimes court means session court. So this has to be interpreted. So here another aspect, my lord. In this judgment, paragraph 43.
Magistrate, just a minute.
Paragraph 43 of the judgment.
43.
In case of error, as per the finding of the session judge, the police investigation has committed an error in not obtaining permission from the court.
1 minute. I marked paragraph 49. Then
49.
paragraph?
Next paragraph 43 of the judgment.
You read 49.
49 first on one point. The next another paragraph is 43. This is another point. Here dealt with another
Same
point.
judgment.
Same judgment. Here in respect of error, if it is apparent to the court that the investigation agency has committed some error.
Paragraph?
Paragraph 43, page 11.
Page 11.
Yes.
Yes. After recognition of the right.
Yes. The police to make repeated investigation under old code in such and such case, it does not held that it does not follow, however, that the individuality of the investigation is to be completely ignored by the court during trial. When the breach of such a mandatory provision is brought to the knowledge of the court at a sufficiently early stage, the court, while not declining cognizance, ordering such reinvestigation as the circumstances of an individual case may call for. Such a course is not altogether outside the contemplation of the Supreme Court.
Okay.
So, in case
And
of error,
other
they can
decisions?
investigate.
Other decisions.
In one, here is a case.
Please.
where the case was initially tried, yes, in ek number, no?
One,
Here relevant paragraph is 4
4,
and 8, 8 and 9.
4, 8.
Here originally case was, my lord, registered under 452, 323. Subsequently, without following any procedure, section, another section is 394 is added
Who?
by the trial court. Now High Court, Supreme Court has said, High Court has, petitioner refused the High Court. There are 3 rounds of litigation. The High Court says yes, Supreme Court says no.
Here the IO has become the judge,
Yeah,
right? Here the IO has become the judge,
yes.
right? He has delivered his verdict
Yeah.
in the charge sheet and everything is created. Entire scenario is
Yeah.
created
Therefore, I have.
for the benefit of whom I don't know. This IO has become the judge.
Yes. So therefore, I have
And
pointing out.
Court has become the IO. Okay.
Therefore, I have pointing out.
Huh.
In case it appears to the court that there is an error, what to be? Reinvestigation. And as the,
Reinvestigation.
yes, that 43 has says, 43 has says, this is the findings of the Supreme Court, man. So that has not been done. Complaint has not been, it should, ought to have been taken. The last option was that it
Okay,
had,
this decision, okay, I'll read paragraph 8, 9, 10, so that I will not conclude, I'll pass the order tomorrow, yes. Decision number 3,
now age determination process. It should be decided as per JJ Act. Paragraph number 3, my judgment number 3. Paragraph 34 and 42, 34 to 42. What are the procedure to be followed in case of determination of age in POCSO case? Here in this case,
medical opinion suggestive, despite recording a finding that 14 years, the medical officer suggested that perhaps above 18 years. It is an opinion. Victim and other witnesses have clearly stated my age is 14, 15 years, right? And this is the issue remain open, which can be decided by the trial court itself. We cannot go into that. That is an aspect which
No.
is beyond the purview of this criminal.
court cannot, my
Court-
humble submission is that, my lord.
We are not into that. We are into the available materials brought on record by the IO and his judgment on POCSO, section POCSO, on the basis of medical opinion,
I have not-
which I think is not the correct and proper procedure to file with his recording.
Here, my lord, we all. are
And
finding
thereafter,
out-
court has the abundant power.
The law.
The way the case has been transferred, that is the only way,
Yeah.
only way of challenge.
Yes.
Other things, court has the
No.
power.
Other thing, not my lord. Another thing I am submitting, my lord. This is my third point of line of argument.
I have found a judgment of the Supreme Court that when it is frivolous litigation, then cost should be awarded.
Here, what
Right.
I am here, my lord.
After examination of 4 prosecution witnesses, the trial is almost to be complete. This petition has been preferred. This is to be pointed out by the
No, that
public
is within
prosecutor
time.
when I
That-
dictate
that
the
has
order
been
tomorrow.
my lord. I have replied, it is within time. So that my friend cannot question my.
No,
They
I have
gone
just,
provided the time of.
so that
I have.
this is the prerogative of the court, Mr.
Yes, yes, you
Don't
can.
make submission. on it.
Therefore, I have
have just
replied, my
reminded.
lord. Therefore, I have replied.
Anything?
Yes.
CL number 4.
Now,
CL
court
number
cannot, my lord, on the basis of oral testimony, determine the age of victim of a POCSO case.
That is a
because-
case of defense. Yes.
Because
Which
section,
paragraph? Recipal.
yes. 34.
Paragraph 34. Okay. And which paragraph of addition number 5?
4.
If court Soros and others,
Recipal is paragraph 29.3. 29.3.
on what point?
That is also age authority to decide determine the age of the victim. Authority. Now, I have not completed my submission on the basis of determination of.
No, others cannot be waited. Next, item number 5. I'll read all the judgments.
Yes.
I'll all the judgments so that paragraph please indicate. We are not deciding it today.
No.
We are keeping it for tomorrow so that I can read your judgment patiently.
Yes.
Inapplicability or applicability.
Judgment number 5.
Paragraph 5.
9.4,
Okay, I have noted down the paragraph.
9.4, 9.5 and 9.8.
9.4, 9.5 and paragraph
9.8.
9.8. Good enough.
Good. So just 1 minute, my lord. For your lordship, my lord. The age determination has to be confirmed as per JJ Act 94, man. On the basis of oral testimony, no, it cannot be.
That is a matter of trial,
Yes.
that whether the lady victim.
What?
Mr. Inazuddin, we are conscious of the time of the court,
Yes, ma'am.
right? And age determination, what way the trial court will decide, that is a matter within the prerogative of the trial court, right?
have-
If it does not go for age determination, it would go in favor of the accused.
Yeah.
We are not into that. Now, shall I pass a direction to go
No,
for?
no, I'm not.
No, why you are making that submission?
Because
Because time is precious.
POXO at burden is, my lord, there is a reverse burden.
That is for a trial court to decide
Had it
oral,
been the case
whether
of-
oral testimony is
Can you
enough.
look in here, my lord?
Mr. Inazuddin, whether oral testimony as regards the age of the victim in the absence of a birth certificate is enough to determine the minority or majority of the victim is for a trial court to decide.
Yes.
Right. Whether it would go for ossification test or not, or any other age determination process under section 94 of the JJ Act, it is for a special court to decide, not to for this court to decide. Right.
But without
Not for a
deciding,
court.
the trial is proceeding.
That,
That
let
comments
them go on. It would be for your benefit. Why you are making submission on it? Don't, time is precious. Please
As a
consider.
counsel, I think it is my duty to point.
Only thing is regarding transfer of the search sheet or case records of from one court to another. I have read enough. I have heard you enough. So on on JJ Act, age determination. This is a matter of trial. Please consider that time is precious for every case.
And also, my lord, your lordship will also consider that he is 309 days as on today on jail.
That is another matter. First, the maintainability of the criminal revision petition.
If you're
Right.
Yes.
If it has merit, it will be allowed, right? Or it is not, it does not have merit, it is to be discarded,
Yes,
right?
of course. I have nothing to say.
Don't make
I am
that regarding the process of age determination. That is a matter within the exclusive prerogative of the special court, right? Not to make any comment on it by the revisional court when
That has
it
been
has not been
determined.
gone into.
That has been determined.
Why you are
before-
making those submissions, irrelevant submission,
Yes.
just to waste the time of the court?
No, my lord, because POXO trial, your lordship knows well over, my lord. And
So
we
why
are-
you are making submission on it, JJ?
Because
That court has made observation session, that you go for ossification. Whether special court would go or not, that is for that court to decide.
I am on.
If I make a direction, do an
Yes.
age determination process either by 94(1), 2, 3.
Three. That-
That it would be, I know in whose favor it would go and against whom it would go. Mister, don't make such submission. I am conscious of all the facts.
I am obliged.
Yes, when your senior would come.
On Monday, Lordship.
What Monday?
Tomorrow.
Tomorrow. Yes, Miss Bora. So many questions have been raised.
Revision petition. Court has very limited power. Only court has to see whether there is any illegality, infirmity in the seat, that the order that has been changed.
First, you address on the point.
Yes,
IO has become the judge
yes,
on the basis of the medical opinion, which is an opinion only,
yes, Lordship.
right?
Yes,
To address on that issue,
Lordship,
it is only the court who can address,
yes.
right? IO made become the judge.
Yes.
Then, since it was registered under Section 4 POCSO Act,
Yes.
it was submitted before the special court, which has a unique characteristic as the court of first instance as well as the session judge,
Session.
right? Then thereafter, court has made an observation and remanded the matter back to the magistrate court.
Yes.
Magistrate court then committed the case, considered it to be a exclusively sessions tribal case under section earlier 376, now I think 65 or 76. Then the court of session judge, having observed that there are materials to indicate that it might be a case of POCSO, the case record had been transmitted to the special court.
Yes.
Whether that act of transmitting the case record to the special court is illegal or beyond the provisions of BNSS or within the provisions of BNSS, that is the issue only.
Yes.
Thereafter, special court has power to take cognizance of offense under POCSO as well as all other offenses
Yes.
associated with it. Right? Section 42 says
Yes.
POCSO as well as 376 and all.
Yes.
Right?
Yes.
So only point of dispute is that transmission.
Yes.
You have to address on that. Nothing else. Tomorrow?
Tomorrow.
As Mr. Ayuddin, learned counsel for the petitioner, Ms. on the request of Mr. Yes. Yes. Your name?
Lordship,
Learned
he wants
counsel
to
for the-
Friday.
Okay. This is the case on so and so. Mr. Sage Paul and additional public prosecutor for the state is present. Ms. Bora, you have to address that. matter.
Lordship, a copy of the order may be furnished to us so that
Copy of?
the order may be furnished to us.
No, you have to address on that point only. I am not recording that, what I have already indicated.
Lordship.
You have the petition or not?
Yes, Lordship.
You go through the case record. The
Lordship.
petition is not complete.
Lordship.
It has excluded some orders.
Lordship.
It has not annexed all the orders.
Yes.
Selective,
The order is against me.
selective orders are annexed. Next.
30-01. Item 14.
May I please your lordship? Lordship, I am the
This is a matter of family code.
family.
Yes,
court.
my lord.
Huh?
I have complied with the last order passed by this honorable court. Lordship. Lordship has rightly recalled.
এই order টো করেছিল। Actually, this is a matter to be decided by the division bench.
My lord, lordship may,
It will go to the division bench.
my lord, I may submit some point, my lord, in this respect, my lord, what lordship raises the issue, my lord. As per that is the notification might be 21st March 2023, my lord. Lordship, this notification, as per my knowledge, my lord, it's only pertain to the civil matter, my lord, not criminal matter, my lord. Only pertain to the civil matter, my lord, not part to the criminal matter.
No, I have forwarded similar matter to the registry,
Yes,
right?
Yes, my lord,
To take a decision in consultation with all the provisions.
my lord.
Thereafter, matters are being listed before division bench. It is
lord-
for the registry to decide.
If lordship may permit, I may only point out one point, my lord.
Which one? 19-1, 2, 3, 4, perhaps 4.
My lord, yes, my lord, 19.
Perhaps 4, subsection 4 of section 19 you would point out.
19.5.
Huh?
5.
5.
19.5.
5. Irregularity, correctness, propriety.
No, my lord, only respect the which, my lord, in this case, my lord, when the magistrate, when the family court exercise the power under 125, my lord, he used the power of the judicial magistrate first class, my lord. That is the section 7, subsection 2 says, my lord. Section 19 of the family court says, my lord, the no, subsection 2 says, my lord, no appeal from the 125 when the chapter 9, this is the falls under the chapter 9 of the CRPC, my lord. When falls under the chapter 9, my lord, no appeal is light, only revision can be light, my lord. Now, my lord,
Which one?
my lord, section 19, subsection 2, my lord.
Huh?
only no appeal lies, my lord, against this order, my lord. When the family court passed any order in the chapter 9, my lord. Now, my lordship may come to my lord, subsection 5, my lord, except as the above shall no appeal or the
You read subsection 4.
my lord. The High Court may of its own motion or the otherwise call for the examination of the record of the any proceedings in which the family court situated within the jurisdiction passed in the order chapter 9 so and so Code of the Criminal Procedure 1973 for the purpose of satisfying itself as the correctness, illegality,
This
legality.
is the revisional power, right?
Yes, my lord.
Revisional power.
Yes, my lord.
So there is some ambiguity in the provision,
Yes, my lord.
right?
My lord.
So this, because of this ambiguity, I have directed the registry to
It's my
to
lord.
consider
My lord.
the entire matter,
My lord.
thereafter the list before
My lord.
the proper bench,
My lord.
right? Because of the ambiguity in the notification also.
Yes, my lord.
And thereafter matters are being listed before the
Yes,
division
yes,
bench.
my
I am
lord.
conscious of all this
My
because
lord,
of
not
the
it.
ambiguity.
It is my apology, my lord.
So despite that, you are repeating it.
No, my lord. I am sorry, my lord. My apology, my lord. My apology, my lord.
Heard Mr. J.P. Das, learned counsel for the petitioner, and Mr.
K.M. Hassan.
K.M. Hassan, learned counsel for the respondent number.
One minute, only one.
Two.
Full stop. Lordship.
Para. An order, final order. By judgment dated 18/8/2025 passed by the Court of Learned, Principal Judge Family Court Number 1, Kamrup Metro, Guwahati, in FC Criminal Number 354/2021, he is under challenge in this criminal revision petition. Full stop. Registry to examine the subject matter of this criminal revision petition. Kua notification number 30 dated 21/03/2023 and dated 22/05/2024. As it is a matter arising from orders and judgments of family courts, and thereafter to list the case before appropriate bench.
My lord. Obviously. Highly obliged, lordship.
First of Mr. Das, learned counsel for the petitioner has submitted that it is second para. The earlier, the direction made in the order dated 16/12/2025
16/12/2025.
in the interim order dated has been complied with within the stipulated time period.
My lord. Highly obliged,
You have
lordship.
received?
Highly obliged. Yes, ma'am. Highly obliged. Obliged.
The interim order to pass earlier to continue till the next date of listing. In interim order,
Lordship.
that order. I mean, you get to the so and so. Yes. Continue na lage. Complied with the order.
Highly obliged, lordship. Highly obliged.
Same in court meeting. Family court.
Yes, Your Honor.
Same thing.
We-
It used to be listed before division bench.
Your Honor, we have prayed for withdrawal of our Wakalatama. Madam Kuntala Dekha is there in this case.
Maharaj, chapter 5 of the High Court, Guwahati High Court rules, 69. You have to file an application, madam.
File the proper application along with that you have sent
Notice.
the intimation
Yes, sir.
to your client.
Yes, Your Honor.
Reasons, madam.
I have already filed Wakalatnama. He has handed over to me with no
Okay.
objection. I have filed Wakalatnama today, Lords.
Okay. Then. Miss K. Devi.
K. Dekha.
K. Dekha, learned counsel, along with Mr.
SP Chittawat.
SP Chittawat, learned counsel, have submitted that they used to represent the petitioner earlier. And during the pendency of this petition, they have handed over the brief to the client in order to engage a new set of counsel, full stop, Mr.
Dr. N. Deca.
Dr. N. Deca, learned counsel, who is in attendance, has submitted that he has entered appearance on behalf of the petitioner by filing an Okalatnama. He has already entered. Full stop. In view of filing of Okalatnama, by Dr. Deca for the petitioner, the names of Ms. K. Deca and S.P. Chitawat, learned counsel, who is to represent the petitioner earlier, are to be deleted, are not to be reflected in the cause list as learned counsel for the petitioner, and to reflect the name of Dr. N. Deca as the learned counsel for the petitioner. First of Mr. S. P. Das, learned counsel for the respondent number 2, and S.H. Bora, edition. Respondent number 1 are present. Appropriateness. This is an order passed by whom? Family Court, no?
Yes, madam.
Final order.
Yes, madam.
No.
It's a final order up to that application. That is at page number, my lord.
Let us see the order.
11.
Page number 11.
No, no.
Interim or final?
It's a final order, madam.
Final order.
Not final order.
Huh?
That is the cause of the case. madam. They have filed a revision, and this honorable court had already observed in earlier order. dated
Rejected.
My lord. So it has attained the finality, my lord.
Rejected. FC criminal. In view of the notification dated so and so, registry to examine the subject matter of this criminal petition arising from criminal revision petition arising from an order passed by the family court. Family court, which place?
Page 11, madam.
Which place?
FC, page 11. FC within
Kamrup Metro.
Family court number 2, Kamrup Metro, Guwahati. And thereafter list the case before appropriate bench.
All right.
Item 16.
Yes. Mr. Who is your senior? NZ doctor. When do we want? Sixth. On the request of Mr.
No, up to 12, my lord. 12, my lord.
No, not 12, no 10 and 12. You take on 9th.
My lord.
On the request of Mr.
Ham.
Learned counsel for the petition, list the case on 9th February.
Item number 17.
Lordship, we challenge the imprint order whereby a petition seeking custody of a vehicle was rejected.
Yes, Ms. Bora. Any report?
Report is required, Lordship. That is not called for.
Just call for
Last
one last opportunity.
Lordship,
is in custody for more than 200 days.
Lordship, just kindly give us a time. We can do the.
What time? Only 1 week.
1 week, Lordship.
Otherwise, we'll proceed.
Lordship.
You are,
In fact, I have got the wrong petition also, Lordship. It's 77
okay,
days.
DK Medi, learned counsel for the petitioner is present. Ms. S.H. Bora, learned additional public prosecutor, has beachesed for another opportunity till next Wednesday, huh?
Lordship. Lordship,
4,
yes.
4/2/2026 to obtain a report from the investigating officer of Rota Police Station, case number 58/2025, as regards the seized vehicle bearing registration number AS01/GE6322. List the case on.
Item 20.
Miss,
BS Ocha, appearing for the respondent number 2 and 3.
okay. There is no representation on behalf of the petitioner today on call. SH Bora, 1, BS Oja, 2 and 3, huh? Are present. Peruse the office note dated 22/01/2026. Await for the as per office note dated 22/01/2026, comma, TCR has not been received. Issue a reminder for the scanned copies of the TCR. The scanned copies of the TCR. List the case on so and so. Yes, Mr.
PD Bhuya.
PD Bhuya for the petitioner are present.
Respect for hearing of the book. No.
What TCR is not received. Where to hear?
23rd February. Item 21.
Please, Your Lordship.
Yes.
Lordship, for this petition, we are challenging the interim order for the custody.
Yes,
of-
case diary.
The CD was called for that we have not received also.
From which police station?
Crime branch, Lordship.
Huh?
Crime branch police station.
Crime branch.
Lordship.
Same thing then next Friday.
Lordship.
Cognac.
Yes, Lordship.
Okay. Cognac or SH Bora likhi dibo. Miss Bora has submitted that she has not yet received the case diary. No. A report from the IO, as regards necessity. It has list the case as sought for by Miss Bora. List the case on 6/2.
Item 23.
May it please, Your Lordship.
Same prayer, Lordship.
Same prayer.
Report was called for.
You can.
Yes, ma'am.
Petitioner SH Bora report as your necessity of retaining the custody of the seized articles stroke items from the IO. In connection with what police station?
Dispur police station.
Dispur police station case number file hobo. আগতো repeat কৰি দিব 6/2. আগতো repeat কৰি দিব. Bora,
24.
Another opportunity নালাগে.
Please,
Last opportunity এনেকুৱা ধৰণৰ নালাগে.
May I please, Your Lordship?
Huh.
This appeal referred to judgment of
Okay.
dated 1912, madam.
Yes, where is the judgment?
Page 16, madam.
Page 16.
From 16.
Art Mr. D.
Boran.
Bora, learned counsel for the accused appellant, and Miss S.H. Bora, learned additional public prosecutor for the accused appellants,
Madam.
Respondent number 1, State of Assam. This appeal under section, this criminal appeal, 415, within bracket 2, Bharatiya Nagarik Surakha Sanhita is preferred against a judgment and order dated 19/12/2025, passed by the Court of Learned Sessions Judge Punitpur Tejpur in Sessions case number 120/2018. Full stop. By the judgment and order dated so and so, the accused appellants many others or what?
There are
How
two-
many are here?
two appellants.
Two, here two.
Two.
Accused appellants.
Yes, ma'am.
2, 3, 7. Along with 6 others,
Yes.
been convicted for the offenses under section 307/34 IPC and section 326/34 IPC. For the offense under section 307/34 IPC, the accused appellants have been sentenced to undergo rigorous imprisonment for 10 years and to pay a fine of ₹20,000 each, with default stipulation. So for the offense under section, for a conviction under section 326/34 IPC, the accused appellants have been sentenced to undergo rigorous imprisonment for 6 months each and to suffer 6 months each. The sentences are ordered to run concurrently. We have gone through the grounds urged in the memorandum of appeal. Memo of appeal. The criminal appeal is admitted for hearing. The case records of so and so be called for, issue notice, returnable on so and so.
6-3.
As Ms. Bora has appeared, accepted, respond number 1. The accused appellant shall take steps for service of notice upon the respondent number 2 by speed post within 3 working days from today.
There's an I also, ma'am.
I
10 years punishment also.
issue notice, D. Bora liquido applicant appellant. S.H. Bora. This application under section 430 B and SS is preferred, seeking suspension of the execution of the sentence passed against the applicant's appellants and for their release on bail, issue notice returnable on so and so as Ms. Bora has appeared, accepted. Opposite party number 1 steps upon the opposite party number 2 by speed post within 3 working days. The state is to ensure that its objection is filed. Its objection, if any, is filed on or before the returnable date.
6-3. Obliged also.
Supplementary list, item 46.
May I please? Excellence the process and the proceeding of
POCSO crossing. POCSO crossing.
Lordship.
Case record not received. Case record was called for.
The receipt, my lord, I have checked.
Received. Not received. You got it by order only. Case record not received. And who has entered appearance?
46.
Scan copy. Status report with case diary.
Yes, Lordship.
From whom?
From the, through registry, Lordship,
So registry. Substitute case.
from the learned additional session just comes special just POCSO, Borpeta.
Not received. Mr.
HM.
S.
HM.
H.A. Ahmed, learned counsel for the petition. And S.H. Bora, learned additional public prosecutor for the respondent number 1, state of Assam, are present. The learned counsel for the respondent number 2 is found absent to the on-call post of, as per office note dated 29/1/2000. Sorry, 29/1. 27/1/2026. The case records of special POCSO case number 145/2023 has not been received. Post-op. Issue a reminder for the scanned copies of the case record of special POCSO case number 145/2023. Please the case on sales.
16-2. Item 47.
When is your next case, the next date?
Next date on day after tomorrow. So finally, I am ready to appear subject to suspension of the equal created after 4 minutes.
1 minute.
Page 24.
1 minute, sir. কালি কি লিষ্ট আছে ন? এইটো পাছ কৰিব পাৰিম। So many other cases tomorrow. At the first half.
Online order is required by the.
No, I don't pass one line order, Mr. Paul. Either I'll dismiss or I'll allow. No one line order without any reason. Tomorrow. Do you have any objection?
No, no.
Tomorrow. We'll pass the order, come in the first half. Remind me at 2 o'clock. If it is not taken up in the first half, then I'll dispose.
Item number 25 for orders.
Yes, Mr.
Pathak has been employed as an amicus curiae, but he is another court willing hearing. Otherwise, the matter is missing orders column.
Why it is for orders?
By order at 10/12/2024, my lord. Person to office on 7/12/2024.
Paperwork is ready.
Yes, ma'am. The service report from Patasan Police Station is awaited, my lord, for response number 2.
Already? Yeah.
No, my lord, the service report is awaited for response number 2.
Who is response number 2?
My lord, the informant.
If none has
Accused number 2.
appeared, and the matter is placed. Is there any order accepting
My lord.
that service is complete?
No, my lord.
Huh?
My lord, there is an office note, my lord, dated.
As regards service
12/24.
notice, shall complete his instruction. Yes, madam. In on 10/12/2024,
Lordship.
the court directed the additional public prosecutor to obtain a service report from officer in charge Patrasar Kusi Police Station.
Lordship.
Have you got it?
Lordship, since
See, this is to be given precedence.
Lordship, otherwise
This
copies of.
matter is to be given precedence, 2009 matter.
Yes, Lordship will take care of it. The box of matter.
And had it been a
Otherwise.
case prosecuted by the state, I would not have insisted, but it is a complaint case.
Lordship.
Conviction is under, in a complaint case.
Lordship.
Maybe he has died or whatever, I don't know.
We'll take the instruction, Lordship.
Mr.
He does, my lord.
B. Das, Counsel for the Learned Counselate, on behalf of the amicus curiae for the revision petitioner is present, along with Ms. S.H. Bora, Learned Additional Public Prosecutor for the respondent number 1 state. 10/12/2012 for the order আছে ন? তাতে লিখিব, সেইখিনি চাই ল'ব, এড্ৰেছ লিখা আছে। Miss Bora shall obtain a report as regards service of notice upon the response number 2, address to likha ase. In deference to the earlier direction given in the order dated 10/12/2024 to establish the case after 3 weeks. Just obtain a report.
Lordship. 25th, no?
Item 26.
You will get in the order the address.
Lordship.
Wait, this is your word. Lordship, in this case, what happened, Lordship, the earlier counsel, N. Ahmed, Lordship, he was expired, Lordship. Thereafter, Lordship, today I have filed an Wakalatnama, Lordship.
And the another say that other counsel lordship, the brief is not with him lordship. When the petitioner approached the.
So you want some time
Yes.
to prepare?
Yes, lordship.
Huh? Mr. B. Chaudhary, learned counsel has submitted that he has entered appearance on behalf of the petitioner recently and wants some time to reconstruct the brief and to make submissions. Ms. S.H. Vora, learned additional public prosecutor for the respondent state is present, post up, in view of the submission made by Mr. Chaudhary, learned counsel for the petitioner, lays the case on suspense.
23rd February, 23 to. It's 3 to.
Kennedy letter third. It's March.
2017 matter, no. February.
Lordship, what happened in this case, lordship? The brief is not with the client also, lordship.
Get certified copies.
Yes, lordship. Thank you.
Item 27.
May I brief, lordship?
Yes.
Lordship, I.
Previous written objection state merely sometime request for argument. What is the case about?
Suspension for suspension.
10 years POXO. Whether service is complete upon the
Service is complete on 17.
respond number 2.
2 years. 17/7, there is an order.
17/7.
Advocate Doctor has appeared you on behalf of 2. Respond on 2.
A doctor.
No name is this one.
Huh? A doctor. Is there any Ukaladama?
Order that there's 17/7.
But his name is not shown in the costly structure as respondent.
A doctor. Who is a doctor? One A doctor has already expired. Huh? Ukaladama ase kintu? Huh? What is it? What is it? Nine. Oh, item 27. Oh, A doctor is there. A Ganguly is also there.
Oh, lordship, sorry, their names are there.
Names
Yes.
are there.
Yes, yes.
This is I. You are for the applicant. Okay.
I'm already behind about more than 3 years.
In POXO case, it does not matter.
Let's see, lordship. Lordship, the whole case.
This was again. Total low. Total low. Duke.
Item 28.
Ziuddin B. Sharma is not service report. Neither ID card. Neither Miss P. Odhikari, learned counsel for the petitioner, and Miss S.H. Vora, learned additional public prosecutor for the respondent number 1, state of Assam are present. Peruse the office note. I want to repeat kore dibo. Kali peruse the office note dated 22/01/2026. List the case on. I got to repeat kore dibo.
Item number 29.
H. A. Amit for the petitioners and Miss S. H. Vora, learned additional public prosecutor for the respondent number 1, state of Assam are present. Post of peruse the office note dated 22/01/2026. Post of neither as per said office note, neither the scan copies can be received. Can be received. The TCA has been received. However, service report in respect of respondent number 2 has not yet been received. Full stop. Await for the service report in respect of respondent number 2. Reach the case on suit.
18. Item 31.
Please, Your Lordship, my lord will kindly produce the office note dated 6/1/26.
Okay, we'll put it put on another date.
My lord.
Right, thereafter we may appoint an amicus.
My lord.
Mr. K. Mohammed, learned counsel for the petitioner. And Mr. R. Kosik, learned additional public prosecutor for the respondent number 1, State of Assam, is present. Peruse the office note dated 6/1/2026. Full stop. Though despite service of notice, despite service of notice, as recorded in the office note dated 6/1/2026, none has appeared to represent the respondent number 2 till date. Full stop. This is a case under what?
My lord, 482, my lord. Earlier,
With what offense?
my lord, regarding SC/ST Act.
Okay. Since none has appeared for the respondent number 2 till date, let the case, for ends of justice, be listed again on the record episode video for appearance of the respondent number 2 till
11/2.
the interim order passed by just will continue till the next date of listing.
11. Items 33 and 34.
Wait, please, Your Lordship.
It is for what?
Lordship is for suspension of the sentence, Lordship. Who convicted under 4 of the POCSO, 10 years, Lordship, 3 years, almost 3 years in jail, Lordship.
Can it be some other date? Immediately in the next week on a fixed date? Okay. Monday?
Can it be, Lordship, first week of March, Lord?
You want to urge on the ground of length of detention?
As well as, Lordship, birth certificate, that birth certificate, Lordship, they issued
Okay.
10 years after, Lordship.
Mr. B. Chowdhury, on the request of Mr. B. Chowdhury, learned counsel for the applicant appellant, leaves the case on Saibo.
6 March, 6/3.
Mr. R. Kosik, present.
Item 35.
Lordship, I'm appearing on behalf of Mr. R. Sharma. The earlier counsel has withdrawn his wakalatnama and Mr. R. Sharma has recently engaged. If you're filing his wakalatnama in
Who will appear?
Mr. R. Sharma.
Okay. Okay. Miss
M. Kakut.
M. Kakoti, you are on behalf of Mr. R. Sharma. Here, learned counsel has submitted that Mr. R. Sharma, learned counsel, would appear on behalf of henceforth. Mr. R. Sharma, learned counsel, would appear on behalf of the petitioner, and he would be filing Ukalatnama soon. Close to Mr.
N.R. Sharma, Lordship, for respondent number 1.
Learned counsel for the respondent.
Number 1, Lordship.
1 is present in view of the submission as requested by Ms. So-and-so. List the case. Within what time he can submit to Ukalatnama?
1 week.
1 week. Okay, after 2 weeks leave.
Lordship, it can be fixed for admission hearing, Your Lordship.
Okay, appear. But he has not filed it. He has made an oral submission.
Lordship.
Lordship, the interim order will be done.
The interim order passed shall continue till the next.
Lordship.
That's true.
Item 36.
May it please your Lordship, can it be taken any other day?
On the request of Mr.
UU Khan on behalf of Ayush Chaudhary.
List the case on. Yes, Mr. Kosik, you are ready. Otherwise, IA suspension. 16 to. Go through it.
Item 37.
As per notice, it says 21 is notice.
How much delay?
85.
A delay the POCSO Act at this stage not required by the statement given 85 days. Allowed.
Item 38.
Petitioner is absent, my lord. We have appeared on our own. We have not received notice. So
Huh?
we have not received notice.
Notice.
Notice has come returned back unserved, but we have checked on the website and appeared. my lord.
38. Okay. Maybe beyond time, so beyond
My lord.
4:30, they have gone home. Okay. Mr. S. Nawaz Land Council has submitted that. You have already filed Kalnama.
Kalnama has been filed, my lord.
He has entered appearance on behalf of the respondent.
Full respondent, my lord.
Sole respondent. By filing Okalanama, but however, full stop. His name is not reflected.
name is there, madam.
Name is there, full stop. Lays the case on side, read. Tosima pisod didi.
Deeply opposite.
Item 39.
Please, Your Lordship. File for suspension of sentences. In the last period, the state was directed to file their objection. But I think the
4:30, yes. File or not file? If not file, how much time?
2 weeks, my lord.
2 weeks. Mr.
R. Ghosh for the
R. Ghosh, learned counsel for the applicant is present. Mr. R. Kaushik, learned additional public prosecutor, has sought listing of has sought for 2 weeks time to file an objection to the application for suspension of execution of the sentence. The prayer is allowed. List the case after 2 weeks.
what is the date? Maybe
2 weeks. Only date 2 weeks by the office.
Item number 40.
May it please your lordship.
Yes, Ms. Deori.
Office note dated 22/1/2000.
R.S. Deori petitioners, R.R. Kaushik, respondent number 1, State of Assam, is present. Yes, office note.
22/1/2026. ID card has not been received yet.
Okay, in view of the office note dated 22/1/2026, await for the service report in respect of the respondent number 2. Full stop. Quashing.
Yes, ma'am.
Okay. Place the case on so and so. Side you are appropriate.
27. Item 41.
May I please your lordship, madam? A is for suspension of sentence, my lord, in connection of this appeal. And in the meantime, my lord, service is completed.
Service complete. No notice has been issued. How can you say? Third, Miss B.R.A. Sultana, learned counsel for the applicant appellant. In the mean, criminal appeal to Tumba Hasan again. POXO or what?
My lord, under section 370.
370.
APC, my lord.
And Mr. R.R. Kaushik, learned additional public prosecutor for the respondent opposite party number 1, State of Assam. Full stop. This application under section 430, so and so, is preferred seeking suspension of execution of the sentence passed against the applicant appellant and for his release on bail, issue notice returnable on so and so. As Mr. Kaushik has appeared, OP number 1, no formal notice, steps upon OP number 2 by speed post within 3 working days from today. TCR received?
My lord, FCR is connected with another.
Has not yet been received. Let the notice made returnable, let them, the state is to file, shall ensure that its objection, if any, is filed within on or before the returnable date.
Item 42.
Please, your lordship. Lordship, as per office.
Mr.
Second, S. Ratta.
Ajay Ratta, petitioner. Kaushik. Where is the office note dated 22/1/2026? Issue a reminder for the TCR. Await for the service report in respect of the respondent number 2. List the case on TCR.
It's not.
Published.
43.
Once the matter may be adjourned, because Mr. B. Fukon had to leave.
Oh, Mr. Dubey, you are still that again. Why it does not come in the up?
Fate of the client, my lord.
Huh?
Fate of the client.
4:30, I get
Yes,
exhausted.
yes, I understand, but other side is also not there. So I being petitioner, my lord, I have to be there.
Okay. Yes, what do you want?
My lord, it's an adjournment on behalf of Mr. Beef.
43. You are Mr.
R. Ghosh.
R. Ghosh,
On behalf of B.
petitioner, R. Kosik, 1. In view of office note dated 22/01/2026. I wait for the service report in respect of the respondent number 2. List the case on so and so.
Obliged.
Item 44.
Wait, please, my lords. My lords, today the matter was fixed for consideration by interim prayer.
Not
And
possible.
of course, my lord, and the two case diaries of the connected matters were called for. that has
One
not
minute.
been
Setting
received.
aside
I've been
crossing
informed.
of Dispur police station case number.
Yes, my lords. My lord, two case
Okay.
diaries were called
A.
for.
Borua, petitioner, R. Kosik, respondent number 1. Okay, case they received?
Not received, my lord.
Huh?
Not received.
From which police station?
Dispur.
Dispur, yes.
On any date on second week of February.
Oh.
My lord, 10, if I may please.
On the, not 10th or 12th. No, kita both letha no? On the prayer of, no, Mr. Kosik. So-and-so has sought for listing of the case on so-and-so in order to produce the case diaries of case number, the Likidiva, this police station case number so-and-so.
Yes,
The prayer for interview is kept open for consideration.
This will be a 13th of February. 16th. Very well. I'm so obliged, my lords.
Mr. R. Dubey, learned counsel for the petitioner is present. The learned counsel for the respondent bank is found absent today on call. Is the case on Mongolbar ba Brihaspatibar did that DDO. Next week. Next week. You remind me.
I have some other matter. Next week, Peter.
You remind me at
Yes, yes.
10:30
I'll
to take up it to take the case at 2 o'clock. Right?
Third difficult. Episode
17.
17th.
Item
Sir.
48.
May I please for your lordship?
Yes, madam, Miss.
In this matter, service report has not. been
Miss,
received,
Miss.
lordship.
Miss
Devashree Chakraborty.
D. Chakraborty, land counsel for the petitioner, R. Kosik present, pays the office not dated 27/1/2026. I wait for the service report in respect of the respondent number 2, list the case on swells.
9.
Yes.